Good morning. This is Wednesday, February 21st. This is courtroom number one. I am Judge Martin. It appears that the prosecutor is here. We're still waiting for defense attorneys to show up. As your attorneys arrive, we will get you connected and get your cases called as soon as possible. And it appears that Mr. Haysha is here early, so we will call 230-835-FY, State of Michigan versus Lisa McGrath. Your appearances, please.
Judge, good morning to you and the staff. Vincent Haysha, appearing with and on behalf of Ms. McGrath, present via Zoom, no objection.
Would you state your name for me, please, ma'am?
Lisa Ann McGrath. Good morning, Your Honor.
Good morning. Today is the day and time scheduled for the adjourned PCC in this matter. Mr. Haysha, the court has received a plea agreement from the prosecutor that indicates that malicious destruction of property, $20,000 or more, will be dismissed and will add malicious destruction of property between $200 and $1,000 and a plea of guilty to count 2, reckless driving, with restitution of $6,866. Is that your understanding?
It is, Your Honor.
Thank you. Ms. McGrath, would you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, ma'am. You may put your hand down. Ma'am, you heard the offer that was just read into the record,
Yes.
and you've had the opportunity to speak to Mr. Haysha regarding the charges you face and the possible penalties.
Yes.
And after having that conversation, ma'am, it's your intention this morning to plead guilty to the added count 3 of malicious destruction of property between $200 and $1,000, and to the existing count 2, reckless driving, with the dismissal of count 1, malicious destruction of property over $20,000.
Yes.
And ma'am, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes, I do.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
I understand.
And ma'am, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes.
Thank you, Mr. Haysha. Ma'am, is it true that on September 8th, 2023 in Huron Township that you did willfully and maliciously destroy or injure a Ford F-150 pickup truck, the personal property of Wayne County Road Commission, the amount of the destruction or injury being between $200 and $1,000?
Yes.
Ma'am, is it also true on that date and time that you did drive a vehicle upon a highway, that being Evergreen Court and Willow Road, in full or wanton disregard for the safety of persons or property?
Yes.
Satisfied, Mr. Haysha?
I am satisfied, Your Honor.
Ma'am, the court accepts your plea of guilty to the existing count 2, the added count 3, and will dismiss count 1. Mr. Haysha, other than the restitution, was there anything else?
Judge, no. If you're asking about immediate sentencing, I can allocate, but I don't believe that there's any other condition associated with this plea, if that's the question.
That is the question. I'm happy to send the matter to probation so you have the opportunity to present more detailed information about your client, but I'm ready to proceed this morning if you are.
I can, Your Honor. Judge, Ms. McGrath is 40 years of age. She has no prior criminal history whatsoever. This event, not to get too deep into things, stemmed around her stumbling upon her husband with another woman nude inside of this F-150 at the time that she made contact. She made what can only be described as an irrational but understandable decision to destroy this piece of property. And I think what was an understandable fit of dismay. And at this point, she's now accepted responsibility and she's going to pay for it. I don't believe she had any intention to harm Wayne County Road Commission property She was acting in the moment in a situation that was highly charged, and made, again, an irrational decision that she now regrets. She's in the process of divorcing her soon-to-be ex-husband, but she is resilient, Your Honor. This is a mother of two who's going to get past this, who understands that she has a debt to pay and wants to move forward very much, and wants to, at some point, get beyond the 3-year mark so that she can hopefully come and expunge these matters. So, Your Honor, I'm asking that you take into consideration the fact that this was an extraordinarily unusual event, something that is, in my estimation, unlikely to ever happen again. With respect to Ms. McGrath, there is no injury. I don't believe, based on an extensive review of this file with the prosecutor, that there's any other restitution here beyond the cost that we've described as $6,866. My client is able to pay that. I'd ask that you consider either a short term of probation or, and I know this is unusual for a case like this, perhaps fines and costs, with an understanding that she must pay this forthwith.
Thank you. Mr. Haysha, the court will impose the following as for count 2, which is the reckless driving. The court will impose a fine of $500, cost of $100. There's $75 mandatory crime victims fee, $50 mandatory state cost, $20 fund fee. As for count 3, the malicious destruction of property between $200 and $1,000, court will impose $500 fine, $100 in costs, $50 mandatory state cost, $20 fund fee. The restitution of $6,866 to Wayne County and place Ms. McGrath on 6 months of probation, non-reporting. But ma'am, the court is going to order anger management. Mr. Haysha, I understand that this was a seemingly isolated incident that was heightened but this occurred on a roadway that is highly traveled, and any number of people could have been in the vehicle at the time of this incident. What I will have Ms. McGrath do is expect a call from probation. There'll be documents for you to sign. They will help you get a payment plan established in this matter. Other than that, is there anything else, Mr. Haysha?
No, Your Honor. I have a program that would allow her to attend anger management remotely. Would that be sufficient with the court?
That would be.
Excellent. Ms. McGrath, I will reach out to you later on today and we'll get that set up. Thank you, Your Honor. I appreciate the immediate steps.
Thank you.
Thank you. Have a good day.
You as well.
Thank you, Your Honor.
Good luck to you, Ms. McGrath. Mr.
Thank you, Your Honor.
Janala, what are we ready with, sir?
Mr. Abdul Latif, Your Honor.
This is 2400008 SM. This is State of Michigan versus Abdelateek. May I have your appearances, please?
Your Honor, respectfully, Sam Jadala, P62186, appearing on behalf of Mr. Abdul Latif. Your Honor, for purposes of today's arraignment, we waive formal reading and stand mute.
Sir, state your name for me, please.
My name is Aliyah Abdelatif.
Thank you, Mr. Abdelatif.
Your Honor, at this time, we're
Go
respectfully.
ahead, Mr. Jadala.
At
Sorry.
this time, we're respectfully requesting a pretrial on this matter. Talk with the state prosecutor. He is sending me both digital and paper discovery.
Mr. Jadala, there's a bond recommendation in the file that indicates that the police department does not oppose personal bond. For that reason, sir, the court will set your bond at 1,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by this court until this matter is resolved in its entirety.
Understood, Your Honor.
February 28th at 9 o'clock, Judge.
February 28th at 9 a.m. Back here with me in number 1. Is there anything else in this matter, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Sir, you have an outstanding bench warrant. This is 2302-520M. This is a City of Romulus case from April the 8th, 2023, at which time you were charged with assault and battery. This file has been in warrant status since May 30th of 2023. Mr. Jadala, were you aware of this?
No, Your Honor, that was 2302-520M.
Yes, sir.
Which jurisdiction was that, Judge?
Romulus.
Romulus. Your Honor, for that matter, we'd waive formal reading and stand mute and just ask that we set for a pretrial also, Your Honor.
Thank you.
February 22nd at 9 o'clock with Judge Oakley.
Mr. Abdalatif, I'm not sure if you heard Mary Ann indicate that the pretrial will be February 22nd, 2024 at 9 a.m. And that will be in person in courtroom number 2 with Chief Judge Brian Oakley.
Judge, I believe that's
There was a bond.
I believe that's a Zoom docket on the 22nd. I'm the House Counsel that day, and I have notification it's a Zoom docket.
Judge Oakley docket by Zoom?
Yes, I believe he does the last Thursday of the month as a Zoom docket. That's what I have. That's what I have in my calendar. I'm going to be House Counsel that day, and it seems as if it's a Zoom docket.
Is that what it is, Mary Ann?
I don't have it indicated on the calendar. I can verify it in 2 seconds.
Give us 2 seconds because Mr. Jadala, the indication from Romulus Police Department, the bond recommendation requests 10,000, 10%, but inasmuch as your client appeared timely this morning without prompting, the court will set bond in this matter at 5,000 personal.
Thank you, Judge.
There was no other condition requested in the bond. I was looking to see maybe the name of the complainant, and I don't. I just see a last name of Salazar. Sir, do you know who that is? You don't need to say it, but do you know who that person is? You don't know who you had an encounter with back on April the 8th, 2023?
No, Your Honor.
Okay. Ugh.
This is all new to me, Your Honor.
Oh, it was an officer. You had some scuffle with an officer during transport on another matter.
Oh, okay.
I just verified it with Heather. It's going to be March 28th. It's a Zoom docket at 9 o'clock with Judge Oakley.
March 28th?
Yes,
March 28th at what time? I'm sorry.
at 9 o'clock.
March 28th, 9 o'clock by Zoom with Judge Oakley. Huh. Thank you, Mr. Jadala. You learn something new every day.
Yes, and tomorrow's docket, because I'm House Counsel, the 222, that's also on Zoom. And look, I believe he's doing one docket a month on Thursday on Zoom.
So the Romulus case, March 28th at 9 a.m. The warrant's been recalled, bond's been set. The state case that was set for show cause arraignment pretrial today is the 28th next week with me on Zoom at 9 a.m. Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Sir, I will see you next week at 9 a.m. You have a great day.
You too, love. Thank you.
Thank you. Good morning, Ms. Oliver.
Good morning, Your Honor. How are you?
I am wonderful. How have you been?
That's good. I'm doing great. Thanks for asking.
Have we seen Mr. Batar yet? I wonder
No,
if Mr. Hadley's here for him. I'm not going far, so if the attorneys come back, I'll be right back.
So I'm like, let me go talk to Jared. Because my only involvement.
Good morning, Detective Carmona.
Good morning.
Really? I know what you meant. I thought it was first turns the week before. It was Oakley, not you. I had my weeks mixed up, so I was stabbing you, it was really him, but I was joking. Never.
Where are the defense attorneys?
I was just thinking the same thing, Judge.
Marianne, if I'm here at 5 minutes to 8, physically here, the least they could do is log on for me, just a little bit. And Mr. Walker's just laughing. I love it. You're fine, sir, trust me. You're fine.
I think we should just proceed with a dismissal.
The prosecutor's here, so that's not an option. I give you an A for effort.
Thank you.
And Mr. Emmanuel was like, wait, let me ask for that too. No, the prosecutor's here, so the case is ready. We're just waiting for the defense attorneys.
Okay.
Marianne, I'm going to go back out in the hallway and round up folks. I think we're back on that.
Works every time.
It never fails. I'm telling you, as soon as I leave the bench. But my light's on. I don't see anybody in the hallway. I'm looking out there right now. What I decided to do was start reading the Constitution while we're waiting for stuff to happen. And of course, I left my copy on my desk. Courtroom number 1 is always doing the most for some reason. Would you get a time for me on March the 6th for the Fanta case, please?
At 9 o'clock, Judge.
This is 240078FD. This is State of Michigan versus Jimmy Thompson. This case was scheduled today at 8:30 a.m. for pretrial. The court received an email from the attorney's office indicating an unavailability to appear this morning and asking that the case be adjourned. It will be adjourned to March the 6th at 9 a.m. with Judge Green.
Judge Oakley, Judge.
Thank you. Judge Oakley in person in courtroom number 2. Marianne will send notice. Have we seen Mr. Thompson this morning?
Not yet.
Okay. Good morning. I'm super. How are you? I'm going to spray you with ginger and turmeric because you're not going to be in here with Marianne. I'm telling you.
Can I have the work?
Thank you. Are you? I'm on.
Oh,
You want to step to your right?
I gotta tell you a story.
I know, I'm coming. Let me just make sure. I'm waiting for attorneys
Oh.
and I'm entertaining Mr. Walker, Mr. Emmanuel, and Mr. Alward. Nope, Marianne, I'm not leaving. I'm just over here with Ken. And see, Mary Ann, this is why we don't leave the door open. Here comes Mr. Zelenik. You are always welcome in person.
I'm just gonna check in for the prosecutor, but I know you wouldn't care, it just works out better.
Whatever works for you.
Judge, it's much better to get up and move your feet around, you know?
I know. Is that Pravanchi?
Good morning, Your Honor.
Good morning, sir. How are you?
Very good. It's Wednesday.
We're here. We're just waiting for defense attorneys. It looks like there might be a few in the breakouts, but there's nothing ready yet.
Your Honor, we are good. You let us know what you need.
Thank you. Appreciate it. Good morning, Ms. Mandernack.
Good morning, Judge. How are you?
I'm super. How have you been?
Good.
Oh, I don't care. What am I gonna do? Make him go on Zoom in the building when I'm sitting up here? That makes zero sense. I'm just trying to get my morning going because we are approaching 8:48 and still waiting for the 8:30s to show up. And then we'll be behind all day and everybody will be shocked that there's no lunch. Yep, we adjourned them. So next week will just be busy. But they're not back-to-back exams, so they're just enough where somebody's gonna take too long this afternoon. Are you intentionally exposing yourself on Zoom? Okay. Is it okay, Mary Ann, that the 8 o'clocks are now failures to appear? Do you think?
Yeah, I do think so.
I see one. Oh, see, I was gonna start, and here comes Mr. Dillard. Good morning, Mr. Dillard.
Yes, good morning, Your Honor.
How are you, sir?
I'm doing good, thank you. I'm just logging in and checking in. And what time do you want me to come back?
For what, sir?
The two cases that I have on there for transportation carriers. It's
Have you
scheduled for
spoken to the
9:15.
prosecutor?
No, is the prosecutor available?
He is.
I will get him in there, Judge.
Thank you. See?
Thank you.
You're welcome. This is 3S4315398A, State of Michigan versus Samantha Bell. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 8:51 a.m. by this court's clock. Defendant has failed to appear again in this matter. Bench warrant shall issue 5,010%. Good morning, Mr. Ambrose.
Good morning.
Have you spoken to the prosecutor?
Previously, I did. I guess what I could do is I could talk to him again just to make sure. I anticipate a dismissal on Mr. DeJuan Jackson's case.
Excuse me.
This is 23BL01054B. It's the State of Michigan versus Maggie Cochran. The case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 8:52 a.m. by the court's clock. Defendant having failed to appear for a second time in this matter. Bench warrant shall issue 5,010%. The court has checked the breakout rooms. There's no one by that name. There are no unidentified persons.
That's fine. Okay. Now, you're on, I've been calling.
This is 220702FY. This is State of Michigan versus Chelsea Crippen. The case was scheduled this morning at 8 a.m. for forfeiture of bond. It's now 8:53 a.m. by this court's clock. Neither the defendant nor the poster have appeared this morning. Bond is hereby forfeit. Take your cap off, sir. These are 23N227105 A and B. These are State of Michigan versus Jared Doherty. May I have your appearance, please?
Good morning, Your Honor. Attorney Josh Hadley, on behalf of the defendant, Mr. Jared Daughtry. Mr. Daughtry, please state your name for the court.
Jared Michael Doherty.
Thank you. Today's the time scheduled for the arraignment and pretrial in these matters. Mr. Hadley, how are we proceeding?
Good morning, Your Honor. We'll waive the formal reading of the arraignment, and we would like to avail ourselves of the people's plea offer at this time. My understanding is Mr. APA Mohammed writing it up now. We'll be bringing it over to the court, but we will be pleading guilty as charged to the case ending in the letter B.
I'm sorry, Mr. Hadley. I was getting background noise. I couldn't hear you. You'll be pleading guilty as charged to which one?
To the B case, Your Honor.
And the A case is dismissed?
That is correct, Your Honor.
Thank you. Sir, would you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You may put your hand down. You've had the opportunity to speak to Mr. Hadley this morning. You understand the charges you face and the possible penalties.
Yes, Your Honor.
And after having that conversation, sir, is your understanding and agreement that you will be pleading guilty as charged to making use of deer bait and the A file, failure to wear hunter orange will be dismissed?
Yes, Your Honor.
And sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, Your Honor.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, Your Honor.
And sir, you're entering this plea freely and voluntarily?
Yes, Your Honor.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No, I have not.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Sir, is it true that on November 15, 2023, the Department of Natural Resources found you to be in Sumter Township baiting deer in an area close to baiting?
Yes, Your Honor.
Sir, the court will accept your plea of guilty as charged in the B file, dismiss the A file, and impose the following. There's $100 fine, there's $100 in cost, there's $75 mandatory crime victims fee, there's $10 mandatory due to the Department of Conservation. There's a $50 show cause fee, $50 mandatory state cost, and $20 fund fee. That's $405. Sir, do you need more than 5 days to pay this amount?
Yes, Your Honor.
Then, sir, what we will do is have you contact the court's collections department. You can come in person and speak to an agent. You may call, or you go onto the court's website. There's a contact us button. You click on that. You submit your request for a payment. When you do that, sir, you have another outstanding matter, speeding ticket, where you owe the court $216. They can put both of these cases into a single payment plan, okay?
Okay, thank you. I was just told
You're
about
welcome.
that.
Anything else, Mr. Hadley?
No, Your Honor, thank you.
Thank you. Good luck to you, sir. You have a good afternoon. Don't forget to contact collections.
All right, thank you.
Thank you. Ms. Mandernack, are any of your cases ready?
I'm ready, Judge, but I haven't spoken to any defense attorneys, and I don't think any defendants are here.
I
think
got
it's-
one. I just need to speak with Patricia.
Oh, okay, perfect.
See how that works?
Where is she?
Ms. Phelps, I haven't seen either of your clients this morning yet, or have you, I don't know if you're queued up to speak to Mr. Mohammed as of yet.
Judge, Mr. Harris is in the, I believe, Oakland County Jail. So they should bring him on. And then
Thank
the other
you.
one, I think the other one, Judge, we have reached a resolution. So yeah, I guess I'll talk to him when he gets on, but yeah.
Okay. Good morning again, sir. Ventus?
Yes, you want us to go forward? Ron?
Yes, please. There's nothing else ready.
I have a-
Absolutely. I'm not going to wait for Ken to come back.
Thanks for letting us come in person.
No worries. I thought you were going to bring your daughter with you.
She's waiting for my mother's house to get inspected for water. My mother is 91. She got flooded when we got flooded in Lincoln Park a couple weeks ago. She lost everything in basement, so they're coming to inspect. My brother just called me. What times? I'm gonna be getting over here. So. But I will bring her next week, Judge. I have something else.
This is 240091 FY. This is State of Michigan versus Darnay Ventus. Your appearances for the record, please.
Edward Zelenak, P276111 for the defendant. Mr. Ventus, please give your full name to the judge.
Thank you. Today is the day and time scheduled for the PCC in this matter. Mr. Zelenak, how are we proceeding?
Subject to your approval, he'd like to take advantage of the offer of pleading to not properly licensing a firearm, which is a misdemeanor, and now he crossed the original charge. He's prepared to enter the factual basis. The court will see when he gives his plea. There's no nonsense. He forgot he had a gun in his gym bag in the back seat of the car, and that's what happened. He's going to forfeit the gun as part of the plea. He has no record. Do you want me to allocute now or after you take the plea?
After I take the plea, please.
Step up.
Would you raise your right hand for me, please? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. Sir, you've had the opportunity to speak to Mr. Zelenak, and you understand the charges you face and the possible penalties.
Yes.
And after having that conversation, is your desire this morning to plead guilty to added count 2, failing to obtain or obtaining a pistol without a license contrary to MCL 750.23A? You understand that if the court accepts your plea this morning, you will not have a trial of any kind. You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor. And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No.
Are you pleading guilty because you are in fact guilty? Sir, take your cap off. This is court. Sir, is it true that on February 11, 2024 in Van Buren Township, oh, I'm sorry, before I ask another question, Mr. Zelenak, have you had a conversation with your client, disclosed that I'm married to an elected official in Van Buren Township? I make that disclosure as Van Buren Township is the issuing agency. My husband's not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about Mr. Ventus's case. He doesn't even know that it's scheduled for today. Thank you. Sir, is it true that on February 11, 2024 in Van Buren Township, you obtained a pistol without proper licensing?
Yes.
Satisfied, Mr. Zelenak?
Yes, we are, Your Honor. Thank you, Judge.
Sir, the court will accept your plea of guilty to added count 2, obtaining a pistol without a license, and dismiss the felony count of carrying a concealed weapon. Mr. Zelenak, what else was it that you wanted to say on behalf of your client,
Just
sir?
wanted to let you know that he works for a local garbage hauler, has a young child, was dropping an employee off from work. They work for the local garbage company. And as he pulled out of the lot of motel, not realizing it's one that there's some interdiction for illicit narcotic activity, he didn't use his turn signal. The officer pulled him over. I had my gym bag in the back, take a look, and they said, oh my gosh, I got my gun in the gym bag. So he agrees to the forfeiture of the firearm and appreciates the opportunity when it's appropriate to come back and ask to have the matter removed from his record. It might be 5 years, whatever the statute provides, but he has no records, so he's entitled to whatever the statute says. That's correct. You have no record? No. Never been arrested for anything? Sorry.
Anything else? Anything else from you, sir?
Yeah, it was an honest mistake. So I put it away from her. I honestly forgot it was there. Usually I carry it the correct way. I had it for a while, never had any prior, engagement with the law. And it just honestly.
Thank you. That being the case, and keeping with what's on the plea form, the court will place Mr. Ventus on 3 months of probation. He will forfeit the gun. Court will impose a fine of $200, cost of $100, $75 mandatory crime victims fee, $50 mandatory state cost, and $20 fund fee. Mr. Ventus, you cannot possess a gun while you are on probation.
Fair enough. Yes.
Other than that, anything else, Mr. Zelenak?
It's going to pay today, Your Honor. Thank you, Judge. Thanks for getting us in person. Appreciate it. Nice.
It's good to see you. It'll probably take 15 minutes or so before the file's ready, because Mary Ann's on with me, and it'll take a minute to put the disposition in.
We'll dispose of it today. Judge, nice seeing you.
Good to see you. Have a good day. Good luck to you, sir. Mary Ann, I'm sorry.
Transportation carrier.
It's in that thing. Oh, no, it's an actual file. My note is, sorry.
That's okay.
When you see it, you'll be like, I was looking for Mr. Hadley to come back. No. The show causes? He doesn't need those. We've done the couple that we're going to do. Everybody else is late. Tell him not to worry about the 8 o'clock. Those are gonna be bench warranted. I've already started. Thank you, though. If they show up, I'll pull the files, but he doesn't need them.
Okay.
Two-three HR 13658 AST. State of Michigan versus Kaman Gavins. This case was scheduled at 8 a.m. for show cause arraignment. Pretrial is now 9:07 a.m. by the court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,010%. Three S 4310237 ST, State of Michigan versus JD Farmer Trucking. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 9:08 a.m. by the court's clock. Defendant having failed to appear. Standard would be a bench warrant, but Mary Ann, I don't know how you can technically bench warrant a LLC. Very interesting. This is 23096 SM, State of Michigan versus Cecil Coleman. Your appearances, please.
I'm sorry, one second.
Good morning, Your Honor. Patricia Mandernack for the people, PA 4088.
Respectfully, Sam Richardala, P62186, appearing on behalf of Mr. Coleman. Mr. Coleman, please say your name.
Cecil Coleman.
Thank you. Today is the day and time scheduled for the final pretrial in this matter. Mr. Jadala, how are we proceeding?
Your Honor, after speaking with the assistant prosecuting attorney, they're unable to proceed. There's no complaining witness. We'd be asking for dismissal in this matter.
Ms. Mandernack?
That is correct, Your Honor.
This case is hereby dismissed. The bond was personal. Is there anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. That concludes this matter. Mr. Coleman, you're free to go. Good luck to you, sir. Have a good day.
You as well.
Thank you. These are 24L563217 A and B. These are State of Michigan versus Nathaniel Jenkins. These cases were scheduled for show cause arraignment. Pretrial at 8 a.m. It's now 9:11 a.m. by the court's clock. Defendant having failed to appear For a second time in these matters, bench warrant shall issue 5,000, 10%. There is another file traveling with it that is in warrant status.
Some tissue.
Thank you.
It's crazy.
Mr. Hadley.
Trying to find Miss Mandernack. Hmm.
Just going through the court proceedings and stuff.
I don't see her.
I haven't been able to find her even when she was in your main courtroom. She's not appearing on my participants. The breakout rooms.
Marianne, we don't know who the NDS is assigned to Mr. Alward.
That's correct.
Maybe Ms. Phelps can help.
Can you tell me the name again, Judge?
His name is Bassam Alward, Bassam, last name Alward.
It looks like it's Mr. Bickert, and I did see him in the breakout room.
He's here. Thank you. Are you kidding me with this? Okay. Yeah. What happened to Mr. Bickert?
I thought he was in a breakout room. Is he not there?
I thought he was too.
No, I don't see him any longer.
All day. Yeah,
240077 SM, State of Michigan versus Shiraru.
Your Honor, respectfully, Sam Jadala, P 62186, appearing on behalf of Mr. Shiraru. Mr. Shiraru, would you please say your name?
Yes,
State your name, sir.
Cornell Shiraru.
Thank you. Today is the day and time scheduled for pretrial in this matter. How are we proceeding, Mr. Jadala?
Your Honor, we're just respectfully requesting a final pretrial, making all witnesses have to appear.
The final pretrial date will be there are people in custody waiting to have their attorneys talk to you.
Judge, I was in the room.
I know.
No attorneys in
There are attorneys in there. I can see them. If I can see them, you should be able to see them. Mr. Wallach, Mr. Dillard, Mr. Ambrose, and Mr. Warbling. What are you? No. What is this?
The final trial, for the jury trial.
No, you're fine. I'm waiting for, I'm sorry, Marianne, I keep talking while I'm trying to get a final pretrial date from you. It's just going off the rails. I'm sorry, Mr. Muhammad, it's not you. It's this, these Wednesdays are so few and far between. I feel like I get rusty in between. Mr. Jadala, I'm sorry, Marianne is in a bit of a thing right now.
I'm
If you
here,
could
I'm
sit
here,
tight.
I'm here, Judge. Did you need another date?
A final pretrial date for Shararu, final pretrial date on a DV case.
Yep, February 28th at 9:45.
Got it.
You said you needed the complainant, Mr. Janala,
Yes, Judge.
CV to appear next Wednesday at 9:45 a.m. back here with me in number 1 by Zoom. Anything else, Mr. Jadala?
Your Honor, I just asked the APA managers to provide discovery to me on Mr. Shiraru and just let her know that, in fact, it is a final pretrial where the victim must appear on Mr. Shiraru.
Absolutely.
Thank you.
Thank you. Anything else, Ms. Mandernack?
No, Your Honor.
Thank you. Mr. Shiraru, I'll see you next week. You have a good day, sir.
You too. Thank you, Judge.
This is 230782 SM, State of Michigan versus Bradley Molly. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Richard Schulman on behalf of Brad Molly.
Good morning, Mr. Schulman.
Your Honor, can we have conversation in chambers perhaps or off the record?
Your name for the record?
Richard Schulman.
No.
Your Honor, Brad Molly.
Thank you. Marianne, we're going to step off for just 1 second. I'm sorry. Would you match up everyone else? If there's anything else ready, I'll be back in a second.
Okay.
All right, all right.
Macomb, I'm sorry. We're still waiting for is this Mr. Walker?
I'm sorry.
Macomb, is this Mr. Walker?
No, this is
Oh, no,
Mr.
I'm sorry.
Emmanuel.
Emmanuel. Okay, thank you so much.
You want us to pass this matter for a moment, gentlemen?
Yes.
Okay. You're protecting me. We need to talk about this. I'm giving you a hard time. No, you don't want to hear it. This is 230496 FY, State of Michigan versus Ronald Rowe. So I lost Mr. Hadley. Oh, Marianne. Good morning, Officer Rep.
Good morning, Judge. How are you today?
I am super. How are you?
I'm doing good, thank
Mhm.
So it's about security.
Mhm.
Yeah.
No.
No.
Oh. Yes. Mr. Jadal, are you ready with something?
No, Your Honor, I just wanted to notify the court that I was going to be covering Mr. Walker for Mr. Bitar. I wasn't sure if Mr. Walker was still with us.
He is.
If you could put him in my breakout room, that would be great, and I'll speak with him.
Absolutely. Thank you, sir.
Absolutely.
Hey, there's somebody logging in from our lobby because there's somebody in the Zoom room. I don't know who he is, but no, he's the very fact that he's standing down in the lobby to conduct this proceeding. That's all. I'm just concerned. Just want to find out who he is so we can get him connected. Okay. Thanks. Bye. How are you today, Officer Barlow?
Good, Your Honor. How are you?
I am super. What are you here for, sir?
For Mr. Shearer, Douglas Shearer.
And
I
that's my
believe it
case
was
as well.
Final pretrial.
Mr. Hadley for Mr. Rowe, 2300496.
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of the defendant, Mr. Ronald Rowe. Mr. Rowe, please state your name.
Ronald Rowe.
Thank you. Today's the day and time scheduled for the pretrial. How are we proceeding this morning?
Your Honor, I have extended an offer to defense counsel. It's my understanding that they are declining it. And I will defer to Mr. Hadley.
Your Honor, would concur. I just obtained full discovery as well as the transcript from a preliminary examination on this one. I'm just going to be asking for about a 2-week adjournment to review all the materials and be able to advise my client on where we're headed next. In addition, Your Honor, after we address that, I do have another matter to address with the court regarding a no contact.
Thank you. We will adjourn Mr. Rowe over 2 weeks, puts us on March the 6th.
At 9:30, Judge, with Judge Oakley.
Thank you. At 9:30 a.m. in number 2 with Chief Judge Brian Oakley. That will be in person, 9:30 on March the 6th. And as for the no contact?
Thank you, Your Honor. Currently, the complainant and the defendant have a 5-year-old child in common. The only modification we would like to make to the no contact order, Your Honor, is that the defendant and the complainant be allowed to text message one another only about the minor child. They do not yet have a Wayne County case number, so they are unable to get onto the WhatsApp or some of the other applications. The people don't have any objection to this at this time, so we would ask the court just to allow, again, the defendant's text message the complainant specifically and only about their minor child and the exchange of parenting time. Which, for the record, Your Honor, is actually going off every week, week on, week off, Sundays at 1 p.m. So it's not about dickering about when this is happening. It's more about the logistics.
Is that correct, Ms. Mandernack?
That is correct, Your Honor.
Thank you. The court will amend the bond to allow for texting only as related to child care and custody. Mr. Rowe, that means child care and custody only. If the court receives reports that your text messaging with the complainant goes beyond that, it could be viewed as a violation of the terms of your bond. Do you understand?
Yes, Your Honor.
Anything else, Ms. Mandernack?
No, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor, thank you.
Thank you. Mr. Rowe, you're free to go. Your hearing date on March the 6th with Judge Oakley. Notice will be mailed to you at the address we have on file. Have a good day, sir.
Thank you, Your Honor.
Mr. Hadley, were you ready with Mr. Shearer?
Judge,
Your
the
Honor,
people are, that's going to be a dismissal.
240020 SM, State of Michigan versus Douglas Shearer.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. Attorney Josh Adler, on behalf of defendant, Mr. Douglas Shearer. Mr. Shearer, please take yourself off mute and state your name for the court.
Douglas Shearer for the court's purpose.
Thank you. The basis of the dismissal, Ms. Mandernack?
Your Honor, today is the date and time set for the final pretrial. It appears that our victim advocate spoke with complaining witness, and complaining witness does not want to proceed in this case. I'm unable to proceed without her.
This case is hereby dismissed.
Thank you, Your
Is there
Honor.
anything else, Ms. Mandernack?
Nothing from the people.
Anything else, Mr. Hadley?
I have one question. Is there any way that I can have the to go get the tether taken off? I have to come up to the court to grab the dismissal, the disposition on the case. Can I have that sent to the clerk for me?
Mr. Mr. Shearer made a notation on the file that we'll release the tether. You said you wanted to come pick up a copy of that?
Yeah, the lady down there at the Dickerson Tether Unit told me that they no longer accept digital copies or anything. They have to be paper because somebody forged something and escaped.
The
So if you
paper
can just get a
copy
copy-
is typically it's just a signed copy of the Register of Actions that indicates release tether.
Yeah, that's what she said. The Register of Actions. We have to get a copy of it. They no longer do digital. If you can have that to the court clerk, I'll be up there and shortly to grab it.
Absolutely, sir.
Thank you so much, Ms. Lee, Your Honor.
You're welcome. Anything else, Mr. Hadley?
Oh, Your Honor.
Thank you. You're free to go. Mr. Shearer, I've made a note that you'll be waiting for a copy or coming to pick up a copy of the ROA to release the GPS tether.
I'll be up there in about 20 minutes.
Thank you.
Sir, you might want to just can you give me maybe more like 45?
Yeah, that's fine. I still got to get dressed, let my dog out. My daughter's sick anyway, so I got to get her ready up and everything for the day.
Thank you. Mr. Mohammed, did you speak to Mr. Ambrose regarding Mr. Jackson?
I haven't.
It's okay. We're back on the record. Nope. Oh, you handed me something else.
Oh, yeah.
230782 SM, State of Michigan versus Bradley Malley.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Richard Shulman on behalf of Mr. Mullins.
Thank you, sir.
Your Honor, looks like the case is going to trial on the first.
Yes, Judge, I spoke to the victim in the case and they very want to move forward 100%, and so we're prepared to do that.
Thank you. And Mr. Monroe was here on screen previously. The court will confirm receipt of the proposed jury instructions, witness and exhibit list. Juror summons have already been sent out. Is there anything else, Mr. Mohammed?
Nothing from the people.
Mr. Schulman?
I just wanted to bring to the court's attention the jury instructions that were proposed by the prosecutor's office were the older version of the instructions. I provided the new version.
You've made my job a great deal easier, Mr. Schulman. I noticed that. Anything else?
Nothing.
Thank you very much. I will see you gentlemen on the date of the jury trial. If anything else comes up between now and that date, please, what is that, March 1st? Please reach out to Mary Ann. Otherwise, I will see you on the 1st. Have a good day. Thank you. Mr. Shears, I think, is on top. Three S 4239743 AST, State of Michigan versus Transportation Carriers.
Yes, good morning, Your Honor. Attorney Joseph Dillard.
Good morning, Mr. Dillard. How have you been, sir?
I've been very well, thank you. And yourself?
Wonderful. It has been a long time.
It has been.
The court is in receipt of a plea form from Mr. Mohammed wherein he indicates that there will be a dismissal of count 1 Oh. But a plea as to count 2 break violation, that's. The misdemeanor is being dismissed and the plea is to the break violation. Was that your understanding?
No, Your Honor. My understanding, but I leave everything to be as represented in writing by the prosecutor, that the registration, that charge is being amended to a civil infraction, and that the breaks, he will be pleading responsible to the civil infraction as to the break violation allegation.
That's what I said, Mr. Dillard. Give me 1 second. Marianne.
Yes.
Mr. Dillard, it's written up correctly. I just did not receive the B file back, but if it's your understanding and agreement in its entirety that the A file misdemeanor will be dismissed and you're pleading responsible on behalf of your client to the break violation,
Yes, Your Honor.
the court will accept your plea of responsible on behalf of your client to the break violation. The fine in that case for the B file is a total of $200. Does your client need more than 5 days to pay that amount?
Yes, Yanni's requesting 60 days if possible.
No, sir, it's not possible. 30 days at the outside.
Okay, 30 days, Your Honor.
30 days to pay. Anything else, Mr. Dillard?
No, Your Honor, that's it. If the court is content with the representations of what's on the paper, and that's as to both file A and B.
Correct, sir. The A file is dismissed. The B file is a plea of responsible.
And thank you, Your Honor.
Thank you, sir. You have a good day.
All right. Bye-bye.
Ms. Quick, are we ready with Ms. Turnage?
Your Honor, I was going to ask if Mr. Mohammed was available for me to speak to briefly.
I'll get her.
Mary Ann will get you moved into, thank you.
There might be a resolution.
Judge, this is Attorney Chariki. I've been bouncing around between different waiting rooms, but I'm supposed to be in with a special prosecutor, Mr. Ryan Lukeski.
And he was here. He's here right now. You want to speak to him right now?
There he
I'm
is.
sorry?
Yeah.
I don't know why
And
you all
Your
don't
Honor,
use chat to
there's,
connect with each other. We'll get you moved into a breakout room, and Miss Phelps was here.
yeah, she put in
I
the
don't know if
chat
she's
that
back
she
from
had
her
to.
exam.
Yeah.
It's Mr. Bickert,
Thank you.
and he was here, and I don't know what happened to him.
I'll give him a call.
I'm already on it. What happened to? Oh, Marianne. Are we ready with Mr. Emmanuel?
Can I please have a breakout room with him?
I don't see him on here anymore.
He would be from the
been on here
Macomb
all
County
morning.
Jail.
Right, he was here.
Okay.
Hmm.
We're just setting an exam date, Judge. If you would allow me to waive his presence, we can do that. I'm gonna go see him coming week.
Thank you. He was here. He had been here since 8 o'clock. This is 220778 FT. This is State of Michigan versus Moses Emmanuel.
Good morning, Your Honor. Adam Wolak, P number 55741, appearing on behalf of Mr. Emmanuel. I know he was present earlier, Judge. I have spoken to him about today's date. Not available at the moment through the Macomb County Jail. I'd ask the court to waive his presence.
Thank you. He was here this morning, sir. He was here for quite a long while. And before the case was called, your indication was that you'd be asking for this case to be set for exam?
That's correct, Judge. We're asking for an exam on March 13th, if that works with your schedule.
It does not, sir. Is discovery complete in this matter?
Discovery is complete.
After next week, sir, I'm off of criminal cases until April the 3rd.
Okay.
And sir, before I schedule that exam on April the 3rd, I want to disclose to you that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the issuing agency of this case. My husband's not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He doesn't even know that it's scheduled. That being said, do you wish to proceed with scheduling an exam, or would you like this matter adjourned for PCC with Judge Oakley?
I wish to go ahead with an exam date, Your Honor.
Is April the 3rd a good day for you, sir?
That is a good date, Your Honor. I would just note for the record, he does have a personal bond in this case, but we have several other matters that have a hold on him. So the length is okay with us. Length of time.
Thank you. April the 3rd at
11:30.
April the 3rd at 11:30 here in person in courtroom number 1. Was there anything else, sir?
Nothing further, Your Honor.
Thank you. Thank you for your patience this morning. Have a good day. If Macomb County brings him back on, we'll let him know. I heard you say that you'd be in touch with him.
I will this week. Thank you, Judge.
Thank you. Mr. Ambrose, I've tried. Did you speak to Mr. Mohammed?
Yes, and he prepared a document. This case is going to be dismissed pursuant to a plea in another matter.
This is 230673 FY, State of Michigan versus Jackson.
Ronald Ambrose appearing on behalf of Mr. Jackson.
State your name for me, please, sir.
Dewan Jackson.
Thank you. Mr. Ambrose, the court just has not received that signed document. Would you put the terms on the record, please?
Yes, Your Honor, that this matter in your court is to be dismissed pursuant to a prior plea agreement in the Wayne County Circuit Court. That prior plea agreement was for this matter to be dismissed. That case in the Wayne Circuit Court is case number 23-004503-01-FH.
Thank you, Mr. Ambrose. The court has noted on the ROA that this case is dismissed as part of a global resolution that includes 23004503-01-FH out of the Third Circuit Court. And when Mr. Mohammed sends in the form, the plea form that indicates as much, it will be added to this file. Was there anything else in this matter this morning?
No, Your Honor, I except for if I could talk to have a breakout room with the clerk, I'd appreciate it.
Marianne, if you have a moment with Mr. Ambrose, please.
Yeah, I put him in with Heather.
Oh, Heather, thank you.
You're welcome.
Mr. Sedlak, have you seen your attorney or spoken to him this morning? Her this morning?
No, ma'am. I've tried to get a hold of her about 3 weeks ago, and she was on medical and said somebody would get a hold of me, but nobody has gotten a hold of me, and I'm here for my court date, ma'am.
I know you are, sir, and I've seen you there waiting patiently, and I have not seen Ms. Frederick log on.
Yes, ma'am. I was wondering, can we do a postponement? I'm still in treatment here in Circleville, Ohio, doing my program.
Sir, give us a moment. If we're not able to get a hold of Ms. Frederick, we will adjourn the matter.
Yep, give me 1 minute, Judge.
I understand. Thank you, Marianne. Give me a moment.
Yes, Your Honor.
Mr. Jackson, it appears that Mr. Ambrose left.
No, I didn't know nothing about that.
I know, he went in to speak to the clerk. I didn't know if he was coming back out. Did he tell you that you needed to stay for something?
No, I didn't. Nobody has said anything. Once you guys said he's going to
Your
break our
case is
room, I thought.
Your
So-
case is dismissed, sir.
Oh, all right. Nobody said nothing to me about it.
No worries. You have a good day.
All right, you too.
Thank you. Forest 4328296, State of Michigan versus Ali.
Good morning, Your Honor. This was Attorney Ben Werbling, P64889 on behalf of Imad Ali.
Thank you, Mr. Werbling. You had a chance to speak to Mr. Mohammed.
I did, Your Honor.
How are we proceeding?
Yeah, we reached a resolution, Your Honor. The original ticket, which was the violation of basic speed law, would be amended to limited access speeding 1 to 5 over.
And you have full authority from your client to enter a plea of responsible to 1 to 5 over.
I do, Your Honor.
The court accepts the plea of responsible when impose a fine of $130. Does your client need more than 5 days to pay that amount, sir?
Judge, can we have 14, Your Honor, just to be safe?
14 days. Anything else, sir?
Nothing further, Judge. Have a great day. Thank you.
Thank you. You too.
Thank you.
Judge, this is Attorney Chirikian. May I be placed in a break room with Mr. Durr?
Yes, sir.
He's dismissed. He's gone. That's the guy that was downstairs.
Thank you. This is 23WM021262A, State of Michigan versus Momar Hamid. The case has been dismissed. The warrant that had been in place is recalled.
You said you have the plea on that one.
Your Honor, may I ask a question?
I'm sorry, give me 1 second. Yes, sir. What's your question?
You asked about my lawyer, and then you said, hold on a minute, and then I don't
I'm
know
sorry,
what to do.
Mr. Sedlak, you're fine. My office reached out to Ms. Frederick's office. They're making a call to find out who is supposed to be covering because she is not available. If we don't have a response in the next 9 minutes, which puts us at 10:15, we'll adjourn this matter over for 2 weeks, which will give my secretary more time to figure out who it is that will be standing in to represent you going forward. I see that you're there. I understand. I appreciate your patience this morning.
I apologize for the interruption. I don't know.
No, sir, don't apologize for the interruption. Although I usually discourage people from shouting out, I know that you've been sitting there ever so patiently. Your case was scheduled for an hour ago. When defendants are here and their attorneys are not, the court makes every effort to get someone on so that you may have the opportunity to speak to someone and hopefully get your matter, if not resolved, at least addressed. And the same thing for the other people in this main session. I see the attorneys are here. They're waiting to speak to the prosecutor. So again, if we have not heard back from Ms. Frederick's office by about 10:15, which is 8 minutes from now, we'll adjourn the matter over for 2 weeks, and they'll give us some time to see if we can figure out who is standing in to provide representation to you.
Appreciate you, ma'am.
Yes, Pravanchi.
Good morning, Your Honor. Is there a status update on Elward? Because we're starting to back up with the 10 o'clocks.
I know, I'm sorry. I don't know what happened to his attorney, Mr. Bickert. He was here and he's gone, and I'm looking to see if there's someone else from NDS here right now that might help us figure out what to do. What I'm actually inclined to do is adjourn the matter over.
Or I could do one court case at another court and dial back in about 10, 15 minutes.
Thank you. That will work.
Okay, Your Honor. We'll see you in a few.
Thank you. Mr. Sharikian, were we ready for these cases to be called?
I'm all set, Judge. Mr. Durr only has one case, is that correct?
I thought that the cases were traveling together, that case and the Harris case. Am I mistaken?
Oh, yes. No. They're tracking together. They're co-defendants. But
Okay.
Ms. Phelps is here from NDS or not, is she?
She was here. She left to go to an exam somewhere else.
Okay, well, I've talked to Mr. Lukeski, who is present, Judge, by way of Zoom, and we've
Mr.
discussed.
Luchesky, did you speak to Ms. Phelps before she left for her exam?
No, we have had a text exchange, however, and she was asking me what date would be good for me for the exam. I believe, and then I subsequently.
I'm sorry. No. I'm inclined to call the case for Mr. Chirikian, and we'll have to wait for Ms. Phelps to come back, but I need just one moment.
Okay.
Thank you. He's here, or I thought I saw him on Zoom.
He's in Zoom.
Okay, was that the three of them?
Yes.
Thank you. This is 230857 FY State of Michigan versus Durr. May I have your appearances, please?
Ryan Lukeski for the people, P73132.
Good morning, Your Honor. Samuel Chirikian appearing on behalf of Mr. Durr, who's present by way of Zoom. Mr. Durr, state your name for the record.
Amir Durr.
Judge, my
Thank
P
you,
number is
Mr.
2.
Durr. Today is the day and time set for the PCC. I'm sorry, Mr. Chirikian, how are we proceeding?
Judge, I've discussed this matter with my client at length, and I talked to Mr. Lukeski. Mr. Lukeski has no objection to a waiver of exam as to Mr. Durr, and I did broach that subject with Mr. Durr. He understands he has a right to an examination, and I believe he understands what an examination is. He's choosing to waive his preliminary examination, knowing he'll be bound over to the circuit court to resolve this matter in the Third Circuit at a later date.
Thank you. Mr. Durr, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you, sir. You may put your hand down. Sir, your attorney has just indicated that you wish to waive your right to have a preliminary examination this morning. Is that correct?
Yes.
And sir, you understand that if the court accepts your waiver of this exam, the next step in these proceedings is that you will be bound over as previously charged.
Yes.
And sir, you understand you have an absolute right to have that exam where the people would have to show that a crime had been committed and that probable cause exists to believe that you're involved in the commission of that crime.
Yes.
And knowing that and having had the opportunity to speak to Mr. Chirikian, again, sir, it's your indication that you wish to waive that exam.
Yes.
And sir, you're doing so freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to waive the exam?
No.
And Mr. Lucheski, any objection to the exam being waived?
No objection, Your Honor.
Thank you. Mr. Chirikian, because you appear on Zoom, there is not a signed waiver in the file. Do you authorize the court to sign the waiver on your behalf and on behalf of your client?
Yes, Your Honor.
Same question to you, Mr. Lucheski.
No objection, Your Honor.
Thank you. This case having been scheduled for PCC, the court having inquired of the defendant, the court will find that the defendant's waiver of the preliminary examination has been freely and voluntarily given. The court will sign the waiver on behalf of the parties. And Mr. Durr, as previously indicated, the next step in these proceedings is that you will be bound over for arraignment on the information, which will occur at the Frank Murphy Hall of Justice. That will be on March the 6th, 2024 at 9 a.m. Your previously entered bond with any of its conditions will continue. Was there anything else in this matter, Mr. Lucheski?
I'm on a video in court.
Nothing from the people.
Anything else, Mr. Chirikian?
Further, Your Honor.
Thank you. That resolves this matter. Mr. Durr, good luck to you, sir. You have a good day.
You too.
Thank you, Judge.
Thank you.
Thank you, Your Honor. I'm going to hang on for Ms. Phelps. Is that, or are we scheduling another time?
If you have the ability to hang on, I appreciate it. Her indication to us is that she will be back. She did not say at what time, though.
Okay, thank you, Your Honor. I'll hang on.
Thank you. These are 24L565670 A and B. These are State of Michigan versus Ernest Lewis. May I have your appearance, please?
Good morning, Your Honor. For the record, Peter Beck appearing on behalf of Mr. Lewis.
Good morning, Your Honor. Deputy Romano, Wayne County Sheriff.
Thank you. Mr. Lewis, state your name for me, please, sir.
This is Ernest Lewis.
Thank you. Today was the day and time scheduled for the arraignment and pretrial in this matter. Mr. Beck, the court has received from Mr. Mohammed, the assistant prosecuting attorney, a plea agreement that indicates that your client will tender a plea of guilty in the A file to failing to display a valid license, and then the B file to limited access. And the thing that he did not address, Mr. Beck, is that there was another file that was traveling with this file, a 2001020T. It's a bench warrant file from Van Buren Township that's been in warrant status since January 5th of 2022.
I believe that that is a violation of failure to complete the requirements that Judge Oakley gave him as far as a charge. I don't remember what the original, I don't know what the original charge was. So it's
As
not a
relates to the, I'm sorry, I was just making you aware of that, but Mr. Beck asked to the 2024 cases, was that an accurate recitation of the plea agreement?
That is the accurate representation, Your Honor.
Thank you. Mr. Lewis, raise your right hand for me, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You may put your hand down. Sir, you've had the opportunity to speak to Mr. Beck this morning. Do you understand the charges you face and the possible penalties?
Yes.
And after having that conversation, sir, is it your understanding that you'll be tendering a plea of guilty this morning to the amended count from driving while license suspended to failure to display a valid license?
Yes.
And sir, is it also your understanding and agreement that you'll be tendering a plea of responsible in the B file for limited access 1 to 5 over?
Yes.
And sir, you understand that if the court accepts your pleas this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes.
And sir, you're entering these pleas freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty and responsible?
No.
You're doing so because you are in fact guilty and responsible?
Yes.
Mr. Lewis, is it true that on January 24, 2024, Wayne County Sheriff's Department found you to be in the city of Romulus violating the limited access speed at 1 to 5 over the posted limit?
Yes.
Sir, is it also true on that day in that location that you had no operator's license on your person while you were operating a motor vehicle?
Yes.
Satisfied, Mr. Beck?
Satisfied, Your Honor. Thank you.
Sir, the court will accept your pleas of responsible and guilty as indicated. Mr. Beck, is there anything before fines and costs are imposed in these matters?
No, unfortunately, Your Honor, his license is still suspended, and I believe that this particular conviction will probably extend.
Mr. Beck, I'm sorry, something happened to your audio.
Your Honor, he acknowledges the fact that he did something wrong. Unfortunately, this suspension will add another year to his suspension, so he's really behind.
Mr. Beck, after you say unfortunately, I can't hear anything else you're saying, sir.
No, Your Honor.
I'm sorry, I wasn't trying to keep you from representing your clients, just something happened with your audio for a second there. Mr. Lewis, in the A file, the no ops is, the fine will be $100, cost of $100, $75 mandatory crime victims fee, $50 mandatory state cost, $20 fund fee. That will be $345. For the limited access, sir, the fine in that case will be $130. In the other file, the 2001020T, the case that had been in warrant status, Mr. Beck, the court is recalling the warrant in that case. And the issue was that he failed to complete 30 hours of community service. Was that your understanding, Mr. Beck?
Yes, Your Honor.
Has he since done that?
He claims that he has done it, but he doesn't have any proof of it. So,
I did turn it to the court. I turned the paperwork to the court. I never got a response. Like I had this one.
he indicates that he has done a community service.
I'm sorry, you said he indicates what, sir?
He indicates to me that he had done community service, did turn over the papers to the clerk, other than the fact that he has a bench warrant that came up once he got these 2 tickets.
Mr. Beck, there's something about how you're sitting that I could hear him, but I can't hear you.
All right, well, hopefully this will be better, Your Honor.
Yep, that's perfect.
All right. No, I mean, he has indicated that he has done or completed community service. Although he doesn't have any paperwork to that effect. He did indicate that he had turned something over to the court personnel. I don't know who it was. And he thought he was completed. Evidently he hasn't. And for that reason, I don't know what else to tell the court.
Mr. Lewis, there is nothing in the court file. I'm looking in it right now. So what we will do is we will amend the requirement to 15 hours of community service within the next 90 days. When you bring your proof of that to the court, make sure you keep a copy and confirm who you filed that with. If you don't have an agency that you have a relationship where you can do those hours, reach out to the court's probation department. They have a list of places where you can get those hours done. As for the fines and costs imposed in the cases this morning, do you need more than 5 days to pay the amount, sir? It will be a
Yes.
total of $475.
Yes.
Then, Mr. Lewis, what I'll have you do is when you're done with Mr. Beck this morning, you can either call the court's collection department, you can come in person and speak to a clerk, or you can go onto the court's website. You can submit a request for payment plan online, okay?
Okay.
Anything else, Mr. Beck?
One more thing, Your Honor. How many hours of community service does he have to complete?
15 hours in the next 90 days. I cut it in half, sir.
Very well. Thank you very much, Your Honor. Have a pleasant day.
You too, thank you. Mary Ann, was there any update from Ms. Frederick's office?
I have not heard a thing, Judge.
Thank you. This is 230685FY. This is State of Michigan versus Matthew Sedlick. Mr. Sedlick has been here for at least an hour and a half this morning. The court has made efforts to be in contact with Ms. Lisa Frederick, the attorney of record in this file. And although Ms. Frederick's not available, the court has been unable to ascertain who it was that would be appearing on behalf of Mr. Sedlick. Sir, inasmuch as you have been here present, ready to proceed, the court will adjourn this matter for 2 weeks. We will put you over onto Judge Oakley's docket for March the 6th.
March the 6th is a it's a Tuesday?
It's a Wednesday, sir.
Okay, Wednesday, March 6th, 9 a.m.
10 o'clock, Judge.
10 a.m., ma'am?
10 a.m., sir. In number 2 with Judge Oakley.
Judge Oakley?
Yes. And sir, did you verify your address this morning with court staff?
Absolutely. It's 2065 Stone Ridge Drive, Circleville, Ohio, 43113, ma'am.
I asked because court staff will mail notice of that new date and time to you at that address.
In the Zoom stuff, please?
Yes, sir. It will be on the notice.
Absolutely. Thank you very much.
Thank you for your patience, sir. You have a great day.
You too, ma'am.
Thank you.
Yes, ma'am.
This is 231033FY. This is State of Michigan versus Robert Lee Thomas III. May I have your appearances, please?
Good morning, Luther Glenn, P38683, appearing on behalf of Mr. Robert Thomas
III, who appears via Zoom from the Monroe County Jail.
Sir, would you state your name for me, please?
Robert Lee Thomas III, Your Honor.
Thank you, Mr. Thomas. Today is the day and time scheduled for the arraignment in PCC. Mr. Glenn, how are we proceeding?
I'd like to set this for a preliminary exam, Your Honor.
Mr. Glenn, have you had the opportunity to speak to the prosecutor this morning?
No, Your Honor.
Oh. Is discovery complete in this matter?
I had discovery.
Mr. Glenn, what the court will do is recall the warrant, indicate that discovery is complete. I'm looking to see if there was a bond recommendation. I understand your clients in Monroe County, but
Yes, ma'am. I served 7 months and I'll be released this Sunday.
this Sunday?
Yes.
Wonderful.
I
Mr. Glenn,
have-
any comment as to bond?
I'd ask for a personal bond, Your Honor.
Absolutely, 5,000 personal. An exam date,
I have, next Wednesday at 2:30 or April 3rd at noon.
April the 3rd at noon is good.
April
Your
the
Honor,
3rd, 2024 at 12 PM. That will be here in person in courtroom number 1. Is there anything else, Mr. Glenn?
No, Your Honor.
Mr. Thomas,
I didn't
thank you
get-
for your patience, sir. I will see you on April the 3rd at 12 PM.
All right. Is there any way I can get the phone number from Mr. Glenn?
Okay, can we go to have a breakout room, Your Honor?
Yes, Mr. Glenn, we'll get you moved back into a breakout room.
Thank you.
This is 201564 FY, State of Michigan versus Ashley Turnage. May I have your appearances, please?
Your Honor, can I have a breakout room with Ms. Turnage? We did receive a plea offer and I just want to communicate that to her.
Oh, okay.
Thank you.
Mr. Rich, have you spoken to your attorney?
I got a message from him saying that he was in a breakout room with the prosecutor.
Okay. Oh, I see him with Mr. Mohammed. Thank you. Two three BL 01042B, State of Michigan versus Trevor Ross Jones. This case was scheduled for show cause arraignment pretrial at 8 AM. It's now 10:28 AM by the court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,000, 10%. Two three L 565700A, State of Michigan versus Jazz Lane Monaghan. This case was scheduled for show cause arraignment pretrial at 8 AM. It's now 10:29 AM by this court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,000, 10%. 3S4308976 ST, State of Michigan versus Antoine Rance son. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 10:30 a.m. by this court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,000, 10%.
Excuse me, Your Honor, I didn't know, am I supposed to leave or?
Were you able to get Mr. Glenn's phone number?
Yes, ma'am, I talked to him.
Then you're free to go. I will see you on April 3rd, sir. You have a good day.
Thank you very much, and I appreciate you, Your Honor. You have a nice day.
Thank you. You too. Heather, I need your help.
Sure, what's up?
Mr. Alward is here and has been here since a little after 8 this morning. Mr. Bickert was here and left, and I can't. If you could get somebody from NDS on, or I know that Marianne reached, or nope. If you could get somebody from NDS.
All right, yep, I will call them. And what was his name again, please?
Alward, ALWARD. First name is BASSAM.
Yep, I will call them right now. Thank you.
Thank you. This is 230-967 SM, State of Michigan versus Stephen Schmidtling. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 10:31 a.m. by this court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,000, 10%. These are 230891 SM, 230892 SM, 230894 SM, and 230931 SM. These are all State of Michigan versus Christopher Walker. May I have your appearances, please?
Your Honor, respectfully, Sam Richardala, P62186, appearing on behalf of Mr. Walker, who joins us from the Lake County Jail. Mr. Walker, would you please say your name?
Christopher Lawrence Walker.
Thank you. Mr. Jadala,
Your Honor,
how are we proceeding this morning?
after speaking with the state prosecutor, Your Honor, and speaking with my client, Mr. Walker is going to be pleading as charged to 2 counts of assault and battery. And Your Honor, he will be pleading under a delayed sentence for 1 count of trespassing. The other matters are being dismissed.
I'm sorry, Mr. Jadala, you said 2 counts of assault and battery and
1 count of trespassing under delayed sentence, Your Honor.
are all delayed or just the trespass delayed?
Just the trespass, Judge.
Does it matter what case is these pleas are in?
No, it does not, Your Honor.
Thank you. Mr. Walker, would you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
The truth. Absolutely, I do.
Thank you, sir. You may put your hand down. You had the opportunity to discuss this case with Mr. Jadala, and you understand the charges you face and the possible penalties?
Yeah.
And after having that conversation, sir, it's your indication this morning that you will be pleading guilty as charged to 2 counts of assault and battery and 1 count of trespassing.
Yes, ma'am, I understand.
And sir, you understand that if the court accepts your pleas this morning, you will not have a trial of any kind.
Yes, ma'am, I understand.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Understood.
And sir, you're entering this plea freely and voluntarily?
Absolutely.
You haven't been threatened in any way, promised anything to get you to plead guilty?
Not at all.
Are you pleading guilty because you are in fact guilty?
I'm pleading guilty because I'm guilty.
Thank you. Mr. Walker, is it true that on November the 12th, 2023 at Detroit Metro Airport, which is located in the city of Romulus, that you did make an assault or an assault and battery upon Lester Anderson?
Yeah, I don't know his name, but if that's his name, that's, yes, ma'am. I'm sorry, I don't know the gentleman's name.
Satisfied, Mr. Jadala?
Satisfied, Your Honor.
Mr. Walker, the court will accept your plea of guilty in 230891 SM. We'll schedule this matter for sentencing and give notice to Mr. Anderson. We will conduct the sentencing by Zoom. We want to allow for a victim impact statement. I'm just looking for the next available probation date. We'll schedule the sentencing for March the 18th, 2024 at 10 a.m. by Zoom back here in number 1 with probation to send notice to the complainant. And then, Mr. Walker, is it true that on that same date, November 13th, 2023, again at Detroit Metro Airport in the city of Romulus, that you did trespass upon the area within the boundary of an approved or licensed airport landing field or other aeronautical facility without the authorization of airport management?
Yes, ma'am, I did.
Sir, the court will satisfied, Mr. Jadala.
Satisfied, Your Honor.
Sir, the court will accept your plea of guilty to the trespass. And as indicated by Mr. Jadala, that plea will be a delayed sentence for 3 months, cost of $200. Thank you. I'm sorry, Mr., not 12 months.
How many months did you say?
He didn't say. I'm sorry, was it 12 months, Mr. Jadala?
No, Your Honor, there was no set amount for the delayed sentence.
3 months?
Yes, Judge.
I'll leave that to your discretion.
Thank you.
I think I have one more.
Thank you. And then Mr. Walker, again, on January 13th, 2023 at Wayne County Airport, sir, is it true that you did commit an assault or assault and battery upon Ali Safyan, Sofyan?
Yeah. Yes, ma'am.
Sir, the court will accept your plea of guilty. Schedule you to return to court for sentencing on March the 18th at 10 a.m. by Zoom, and with the probation department to send notice to the complainant in this case so that they may come and provide an impact statement to the court. The last case and the count 2 in that case, trespass will be dismissed. And then the last case will be dismissed as well. This is 230931 SM. Was there anything else, Mr. Jadala?
Nothing further, Judge. I just wanted to notify the court that my client is at the Lake County Jail facility serving a sentence. He began on January 13th, and his out date is scheduled around March 18th. He's not sure if he'd be getting any credit, but I'll just notify him to make sure that he responds to probation and stays in contact with them to let him know if he's going to be released or still incarcerated.
Thank you, Mr. Jadala. Was there anything else, Mr. Walker?
No, ma'am. I hope.
Thank you for your patience today, Mr. Walker. You have a good day, okay? I'll see you on March the 18th.
Thank you, Judge.
Okay.
This is a recall of 201564 FY State of Michigan versus Ashley Turnage.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Ashley Turnage, who is present in the Zoom.
She had been and now I don't see her. Hold on 1 second.
In the breakout room, maybe?
Yep, I'm grabbing her.
Thank you. She's here. Ma'am, turn your video on, unmute yourself and state your name for the record, please.
Ashley, if you can hear us, please unmute yourself and turn your video on.
Ashley Turnage.
I just sent her a message. We were just speaking.
And she's now left the session.
Wonder if she's having connection issues. I just sent her a message.
Moammar Hamadi.
Judge, we need to ask Deputy Pravanchi when he comes back if Rashaw is there. He never mentioned him.
He was in custody when I checked a few days ago.
Yep, that's what Heather said.
Miss Davis.
Yes.
Ma'am, have you been in contact with Mr. Is it my show?
Yeah, Mashar, he's in custody, ma'am.
Okay, we're trying to locate him. Thank you.
You're welcome.
Miss Rich. Three S 4301745 ST, State of Michigan versus Jermaine Williams. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 10:24 a.m. by this court's clock. Defendant having failed to appear for a second time in this matter. Bench warrant shall issue 5,000, 10%.
Judge, Miss Turnage is back. She was unable to unmute herself.
This is a recall of 201564 FY State of Michigan versus Ashley Turnage.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Ashley Turnage. She is present via Zoom. Ms. Turnage, would you please unmute and turn your camera on? I did just speak with her on the phone, and she was telling me the same thing, that she was having trouble unmuting, though I was able to speak with her in the breakout room twice, so I don't know.
Three S 4311116A, State of Michigan versus Yusuf Tahir Hassan. The case was scheduled at 8 a.m. for show cause arraignment. Pretrial is now 10:46 a.m. by the court's clock. Defendant having failed to appear again in this matter, bench warrant shall issue 5,000, 10%. Mr. Lachowski? Lucheski? I'm sorry.
It's Lukeski. I'm here, Your Honor.
Thank you. Ms. Phelps has not returned. And this case was scheduled at 9:15. It's now 10:47. This court is moving towards its exam docket. My inclination is to adjourn the matter over for a week or two.
That would be fine, Your Honor. Could I ask the court one question?
Sir.
If we had a mutually agreed on exam date, and I don't have it yet because I haven't received a text back because I believe she's on the record in an exam, could we file something that would put it on an exam date that we chose on a Wednesday?
I'm not ignoring you, sir. I'm just looking for the file. This is 230858 FY State of Michigan versus Devon Harris. That's not how it would work. If we are adjourning this matter over, if I put it over for a week, you're with me and you can reach out to Mary Ann to confirm a good Wednesday date. If you want 2 weeks, you'll be on Judge Oakley and you'd reach out to Heather for a date. So that's, if you have a preference.
Oh, and you're, maybe I should ask this question first. Could we get another PCC date? Because I don't want to set an exam date without Ms. Phelps' agreement and call witnesses out for a false alarm.
I'm sorry. I must not have said it clearly. What I was saying was, if you ask for a 1 week adjournment, I'll do it next Wednesday with me, PCC, and we can pick an exam date.
Perfect. That would be great.
If you want
I'm
2
sorry, I
weeks,
misunderstood.
no. If you want 2 weeks, what we would do is put it over for 2 weeks for PCC. You'll come back with Judge Oakley and pick an exam date then.
No, I'm good with the week, Your Honor. I appreciate the court's patience.
10:15, Judge.
Thank you. 10:15 on February 28th, 2024, back here on Zoom in number 1. And if she returns, I'll advise her that that is the exam. I'm sorry, that's the adjourned PCC date.
Thank you, Your Honor.
And if you speak to her in the interim and there's something else, just reach out to Mary Ann.
Yes, Your Honor. Thank you.
Anything else?
No, nothing from the people.
Thank you very much. I'll see you next Wednesday morning.
Thank you.
Judge, this is Attorney Cheryl Quick. I have Ms. Turnage on the phone. She's been trying to unmute through Zoom, and she's saying that by pressing the microphone, it's not something's not working. And I suspect that because of where she is, she's not getting good signal. And so I don't know if the court will allow me to put her on speakerphone. I have her on my phone right now.
I'm sorry, Ms. Quick, were you able to see her when you were speaking with her before?
Yes. And I've spoken with her now twice in the breakout room and twice on the phone.
Okay, the information that I have, I'm sorry, I received a plea form from Mr. Mohammed in 201564 with the
Yes, sir.
indication that she'll be entering a plea of guilty to the added count of obtaining a pistol without a license.
That's correct, Your Honor. That was our intention this morning.
And Ms. Quick, I'm always reluctant to enter a plea when I can't see who the person is that I'm speaking with. And if you were able to see her and hear her before, I'm concerned that she's now not available to the court. You said because of the area she's in?
Judge, I'm sorry. I'm not sure what's going on with my phone, but I'm having some technical difficulties with it. It lets the video show in the breakout room. I'm not sure why when we go to the live meeting, it's not letting me unmute or show the video of me.
Ms. Turnage, I'm sending a signal right now for you to start video.
Well, let me see if I can do it.
Ms. Quick, if it's not going to work, what I indicated before was that the plea was to, there we are, thank you, ma'am, was obtaining a pistol without a license contrary to MCL 750.232A, that she would forfeit the gun and that she cannot possess cannot possess a gun while on probation. Was that your understanding?
It is, and I do see Ms. Turnage now on the screen. I'm not sure if she's connected, though, to the sound because I'm only hearing her through my phone now. But maybe we can make that work now that the court can see her.
That's why I can share, her audio is working now, and that's why I asked you, was that the extent of the plea?
Yes.
Ms. Turnage, would you raise your right hand for me, please, ma'am? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Ma'am?
I think her audio is not working. I think she's only able to hear through my speakerphone. Can you hear us now, Ms. Turnage?
Yes, I'm raising my right hand.
Thank you. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. You've had the opportunity to speak to Ms. Quick and you understand the charges you face and the possible penalties.
Yes, ma'am.
And after having that conversation, ma'am, is it your intention this morning to plead guilty to the added count of obtaining a pistol without a license?
Yes, ma'am.
Ma'am, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, ma'am.
And ma'am, you're entering this plea freely and voluntarily?
Yes, ma'am. Yes, Your
You
Honor.
haven't been threatened in any way or promised anything to get you to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Repeat that, please.
I said, are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Ma'am, is it true that on October the 10th, 2020, in the city of Romulus, you obtained a pistol without proper license?
Yes, Your Honor.
Ms. Quick, would you like to inquire further of your client?
Your Honor, defense is satisfied.
Thank you. Ma'am, the court will accept your plea of guilty to the added count of obtaining a pistol without a license and will dismiss the original charge of carrying a concealed weapon. Ms. Quick, was there anything else before fines and costs are imposed in this or before sentences imposed in this matter?
Your Honor, I'd just like the court to know, Ms. Turnage actually lives in Mississippi. She has always lived there. She was in Michigan briefly, and that's when she was arrested. So we would ask the court to consider phone reporting for probation. She does not have the funds to travel back and forth. And in fact, Ms. Turnage, her housing situation is pretty unstable right now. And so with regard to costs and fines, we would ask the court to consider that as well.
Ms. Turnage, the court will impose the following: a fine of $100, cost of $200, $75 mandatory crime victim fee, $50 mandatory state cost, $20 fund fee. The court will place you on 3 months of probation. You may report by phone. The gun that was seized will be forfeit. You may not possess a firearm while you're on probation. Was there anything else, Ms. Quick?
No, Your Honor.
Thank you. Ms. Turnage, did you verify your phone number and address with court staff before the case was called this morning?
Yes, Mayor.
Then, ma'am, what I'll ask you to do is to contact the court to set a payment plan. You can either do it online or you can call and speak to a collections department. Probation will be in touch with you at some point to put you formally on probation, but I want you to be aware that you need to make arrangements for the fines and costs, okay?
Yes, ma'am. Yes, Your Honor.
Anything else, Ms. Quick?
No, thank you.
Thank you. Ms. Turnage, good luck to you, ma'am. Have a good day.
Thank you.
Have a good day, Your
This is
Honor.
2400, you too, ma'am, 240092 FY, State of Michigan versus Howard. May I have your appearances, please? Mr. Bickert?
Hello, good morning. My name is Bassam Alward, Your Honor.
Thank you, sir.
Yes, Your Honor, I apologize. I was on mute. May it please court, Your Honor, Tyrone Baker appearing on behalf of Mr. Alwood.
Thank you. Today is the day and time scheduled for the PCC. Mr. Bickert, how are we proceeding this morning?
Your Honor, I've discussed with Mr. Alwood his right to a preliminary exam, the people's burden to establish probable cause and how they would attempt to do so in his particular case. Given our discussion, Mr. Alwood would like to waive his right to preliminary exam and agree to be bound over, Your Honor.
Thank you. Mr. Alwood, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you, sir. You may put your hand down. You've had the opportunity to speak to Mr. Bickert this morning. You understand you have an absolute right to have a preliminary examination in this matter where the people would have to show that both a crime had been committed and that probable cause exists to believe that you were in commission of that crime.
Correct.
And sir, after having that conversation with Mr. Bickert, you wish to waive your right to that examination?
Correct.
And Mr. Alward, have you been threatened in any way or promised anything to get you to waive that exam?
No.
Sir, you're doing so freely and voluntarily?
Correct. Yes. Yes, ma'am.
And you understand that if the court accepts the waiver of the exam, the next step in these proceedings is that you'll be bound over for arraignment on the information that will occur at the Frank Murphy Hall of Justice.
Yes.
Mr. Mohammed, do you have any objection to the waiver of Mr. Alward?
No objection, Judge.
Mr. Bickert, because you appear on Zoom and not in person, there is not a signed waiver in the file. Do you authorize the court to sign the waiver on your behalf and on behalf of your client? You're muted.
Yes, please, Your Honor. I'm sorry. It was kind of
Thank you.
noisy.
No worries. Then, Mr. Bickert, the court is executing the waiver on your behalf and on behalf of your client. Mr. Mohammed stepped into the courtroom and gave his consent as well. The court has signed that. And Mr. Howard, before this matter is bound over, Mr. Bickert, you had some comment as to bond in this matter?
Your Honor, yes, Your Honor. I would ask the court to consider. It's my understanding that Mr. Howard has a $5,000 10% bond. Your Honor, I don't believe, I mean, the charges in this case, while we don't mean to diminish them, I would indicate that he's not actually accused of assaulting a police officer, Your Honor. He's accused of failing to comply. I would ask the court to consider a personal bond for Mr. Howard. It's my understanding that, quite frankly, that he expressed remorse for his behavior immediately at the scene, and that, quite frankly, I don't believe that he presents any danger to the community, Your Honor. He certainly will appear. He doesn't really know, the charge just, it doesn't really lend itself to him not appearing, Your Honor. So I would ask the court to consider
Thank you.
a personal bond.
Absolutely. Mr. Bickert, your request is granted. Mr. Alwart's bond will be amended to a $5,000 personal bond. Other than that, Mr. Albert will be bound over as charged to the Frank Murphy Hall of Justice. That arraignment on the information will be on February 28th, 2024 at 9 a.m. Was there anything else, Mr. Bickert?
No, Your Honor, not on behalf of the defense, excuse me.
Thank you. Mr. Albert, good luck to you, sir. You have a good day. Good luck to you.
Thank you, you too.
Mr. Rich. 240079 SM State of Michigan versus Philip Rich.
And good morning, Your Honor. Kevin Kiefsky, P74 153, appearing on behalf of the defendant, Mr. Philip Rich, who appears by Zoom, has no objection doing so. Mr. Rich, can you please state your full name loudly and clearly for the record?
Philip Rich.
Thank you. Today is the day and time scheduled for pretrial in this matter. How are we proceeding this morning?
Your Honor, the people and the defendant have come to an agreement along with the consent required by the victim for a delayed adjudication under 769-4A. And I believe that the plea form has been tendered by the prosecutor to your chambers or to the court.
Thank you, sir. The plea agreement that the court has received indicates that Mr. Rich will plead guilty pursuant to MCL 769.4A. That since this matter will be delayed for a period of 12 months, that he is to have no contact with Amber Rich or the children. He will have a mental health evaluation and any treatment recommended from that evaluation, that he will engage in anger management classes. Was that the extent of your agreement with Mr. Mohammed?
That is correct, Your Honor. And as well, I know it probably wasn't written on the form, but if the court is so inclined, I believe that Mr. Mohammed would also state that we would be amenable to immediate sentencing and skip the PSI, but we'll defer, of course, to what the court desires.
Thank you. Mr. Rich, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. You've had the opportunity to discuss this case with your attorney, and you understand the charges you face and the possible penalties.
Yes, I do.
And after having that conversation, sir, is it your understanding and agreement that you will be tendering a plea of guilty as charged to count 1 domestic violence?
Yes.
And sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
I didn't get the last part. I'm sorry.
I said you will not have a trial of any kind if you enter a plea this morning.
Correct.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine the witnesses put forth by the prosecutor.
Correct.
And sir, you're entering this plea freely and voluntarily?
Yes, ma'am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Mr. Rich, is it true that on February 6, 2024 in Huron Township that you did make an assault or assault and battery upon Amber Rich?
Yes, ma'am.
Thank you. The court will accept your plea of guilty as charged to the one count of domestic violence as indicated by your attorney and agreed by the prosecutor. This plea is taken pursuant to MCL 769.4A. Sir, you will be placed on, I'm sorry, Mr. Kajewski, was there anything else before the fines and costs and sentence are imposed in this matter?
No, unless the court would like to have brief allocution, but I'm willing to waive that because I believe that the case is relatively straightforward.
Thank you. And as indicated, Mr. Rich, the court will place you on 12 months of probation. You will have anger management classes. You are to have no contact with the complainant, in this case, Ms. Amber Rich, or the children. You will have a mental health evaluation and any treatment recommended by that evaluation. The court will impose a fine of $500, cost of $100, $75 crime victims fee, $50 mandatory state costs, and $20 fund fee. And Mr. Rich, the court's probation department will be in contact with you at the address, email, phone number that you provided to put you formally on probation and to assist you in enrolling in the anger management classes and having the mental health evaluation. Was there anything else on behalf of Mr. Rich?
Yes, Your Honor. The sister slash victim in this case, her home where the incident happened, my client used to reside there. Absolutely no contact, but he does have several personal belongings. So I'm curious if this honorable court would permit ordering a civil assist so that he would have one opportunity, one time to retrieve his personal belongings sometime in the next few weeks, but of course, subject to the availability of police and also the victim.
One civil standby as arranged through Huron Township Police Department and in cooperation and consultation with Amber Rich. And the court will note that the plea form received from Mr. Muhammad, the APA in this matter, indicates that Ms. Rich did approve of this plea agreement. If there's nothing else in this matter.
I think we're all set from the defense, and thank you very much, Your Honor, for your time this morning.
Thank you. Mr. Rich, good luck to you, sir. You have a good day.
Thank you, you too.
Thank you.
2S39, I'm sorry, Ms. Phelps. Mr. Lachewski left 230858 FY State of Michigan versus Devon Harris.
Yes, he texted me. I'm so sorry I got pulled away, but he texted me March 27th. Is that what we set for that one?
February 28th for Harris?
Oh, no, so he is in custody in Oakland County. Unfortunately, I'm not available that day, but also I don't think they could writ him out fast enough. Let me pull
No, Ms. Phelps, it was set as a PCC.
Oh, to come back. I'm sorry.
We would have had to call
I'm
them.
sorry. Hold on one second, Ms. Phelps.
I'm sorry to interrupt, but my understanding is there was a plea on that case, no?
No, he's thinking of the other case.
Okay. Okay.
It was a PCC because he wanted to discuss a possible scheduling of a exam.
Right. Okay.
Are you able to do that next week, or do you want to?
The 29th.
28th, next Wednesday.
Oh, on Zoom. Yeah, I can do.
Wait, are we talking about the right case?
We're talking about Devon Harris, the one with Lukeski.
Yes.
Yeah. He had texted me some exam dates, but maybe that was before he logged off. So, yes, I can come back on the 28th to schedule the exam with him. And so it looks, did they ever bring him from Oakland County?
No.
So, thank you so much.
I never saw him this morning.
Okay. So, I mean, I'm in communication with him. So if we're just coming back to schedule that, I think that's okay for me to waive him and then we'll just get it scheduled and then, okay. That sounds good to me.
Thank you.
Thank you, Judge. And Judge, is that with you again, or is that?
That's back with me.
Okay, great. Thank you.
Thank you. This is 210736 FY, State of Michigan versus Frank. Is it Mishu?
Michaud, I believe.
Michaud, thank you. Your appearances, please.
Judge, I'm not sure if we're waiting for the prosecutor, but on Mr. Michaud's behalf, I would say that I'm not sure if Mr. Michaud wants me to continue to represent him. I think he's expressed previously that he does not want me to continue to represent him. I'm happy to be here as some sort of standby counsel, but I'd prefer that Mr. Michaud sort of speak to whether I'm representing him or whether he intends to represent himself.
Give me one moment so we may get the prosecutor's appearance.
Good morning, Your Honor. Mohammed Mohammed on behalf of the people, P86771.
Thank you. And Mr. Michaud, your name for the record, sir.
I am the beneficiary of the Frank Anthony Michaud Jr. estate, making a special appearance, not general, and I appoint you as my trustee for the record.
And Mr. Michaud, were you able to hear Mr. Sullivan indicate that he is standing by as shadow counsel?
I heard him.
Okay. This case is scheduled this morning for PCC. How are we proceeding?
I'm here challenging the jurisdiction for the record, ma'am.
Judge, the people are prepared to set a preliminary exam in regards to this matter.
Mr. Michaud, you're able to raise that at the exam date, the allegations that these events occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you ready to have the exam scheduled, sir?
I'm not here to
Mr.
have an
Michaud?
exam. Still trying to wonder why we moving forward with even having an exam, especially after not having by the due process even having a probable cause hearing.
It's not a problem, it's probable cause conference, sir, at which time the parties will indicate if they're ready to proceed to exam, if there's a plea or a waiver or some other resolution. So at this time, the assisting prosecuting attorney has requested that an exam be set. Are you prepared to have the exam scheduled?
No, as me here challenging the jurisdiction for the record, I want to put on the record that once the jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That's Mello versus US for the record.
And sir, what is it that you find, what is your allegation regarding the jurisdiction?
Well, what is the jurisdiction that the court is operating up under, ma'am? The Sixth Amendment.
The court is already,
the right
Mr.
to know.
Michaud, the court has already indicated that the allegation is that this event occurred at Detroit Metro Airport, which is located in the city of Romulus.
Under
Are you
what
indicating
juris-
that this event that brings us here to court did not occur in the city of Romulus?
Well, I would like to know what jurisdiction is this court operating up under so that I can properly defend myself and represent myself for the record. So the Sixth Amendment grant me the right to know the nature and causes of these actions. So I would like to know what jurisdiction are you operating up under?
Sir, what the file indicates is that there's an offense dated February 23rd, 2021. And again, that the case happened at Detroit Metro Airport, which is located in the city of Romulus. That is a jurisdiction within this court's parameters. So that being the case, would you like to have an exam scheduled?
No, I would like to have, under what jurisdiction are you proceeding with so I can properly defend myself? Under what
I've said
jurisdiction?
it three times already, Mr. Michaud. If you have indications or information that the event as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or admiralty jurisdiction, or is, for the record? You gave me a location.
Michaud?
The jurisdiction.
Mr. Michaud, respectfully, what we'll do this morning is either schedule an exam, adjourn the PCC, or waive the exam. One of those three things.
Well, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. That's Higgins versus Levine. So I still would like to know under what jurisdiction so that I can properly defend myself, not the location. I need to know what jurisdiction is this court operating up under.
Mr.
It wouldn't
Michaud,
be a violation of your oath of office to tell me.
Mr. Michaud, for probable cause conference, and I'm sure that you've heard this before, we're doing one of a few things. We are scheduling the exam, we're adjourning the PCC, or we're waiving the exam. How are we proceeding?
We can't proceed until jurisdiction is proven on a record so that I can fully have an understanding of what's going on. I still don't understand what is going on without jurisdiction being proven on the record.
What don't you understand, sir?
I don't understand what jurisdiction are you operating up under. I have the right to know. And are you denying me my right to know what jurisdiction are you operating up under? Because it is your constitutional oath to let me know what jurisdiction it is that you are operating up under. And you still have not yet given me my right.
This is the 34th District Court, Mr. Michaud.
That's not a jurisdiction. That's not a constitutional jurisdiction, ma'am. Is this common law or admiralty? Is this criminal or civil?
It's a criminal case, sir.
Okay, if this
It's
is
a criminal case where it's alleged that you were a felon in possession of a firearm and that you carried a concealed weapon, that's count 2, and then count 3, felony firearm. Those are the allegations. I've given you the 3 counts in this matter. I've given you the date of the offense, and I've given you the location of the offense. We can do one of 3 things this morning, sir. We can adjourn the PCC, we can schedule the exam, or you may waive the exam. Which would you like to do this morning?
I want to have my rights given to me, and my right is to have the jurisdiction of the court. That's just for the record.
I've already indicated to you, sir, what the court is.
Is this common law or admiralty? That's the only jurisdictions that we can, that I know of. You still haven't acknowledged neither one, and I still don't understand what's going on. Until you acknowledge one or the other, we still haven't got jurisdiction on the record.
Mr. Michaud, do you intend to represent yourself in this matter going forward?
I would like to know jurisdiction so I can properly proceed to present myself properly. I can't properly present myself or defend myself without knowing what jurisdiction that you're operating up under. And you said it was criminal, so if it's criminal, and for a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction imposed or penalty imposed on one because of this constitutional right. So if this is a criminal, where is the injured party? Who have I injured? I have the right to face my accuser, face the one who is bringing these allegations against me, ma'am.
Mr. Michaud, if you wish to be able to defend yourself and hear witnesses against you, the court is happy to schedule the exam. Is that what you're asking this morning?
No, as I appointed you as my trustee, I demand that you dismiss these actions for no corporate selecti, no proper jurisdiction, for no proper crime, injured party.
Mr. Muhammad, your response to Mr. Michel's request that this case be dismissed.
Judge, the people's position is we would object to dismissing this case on the basis of lack of jurisdiction. As you mentioned earlier, this crime did occur in the county of Wayne, and thus we do have jurisdiction.
There is no jurisdiction without an injured party, for the record. So I would like to face the injured party for the record.
And Judge, my response is, then we should
Yes, sir.
then I believe we should set this for a preliminary exam.
I object to that, ma'am. You cannot proceed without jurisdiction being provided on the record. And you being my trustee, for the record, ma'am, you have to dismiss this case as I demand, for the record.
Your request to have this matter dismissed is denied. Mr. Michaud, my question will remain the same. Would you wish the court to schedule an exam? Do you wish to waive that exam and have your case bound over to Third Circuit Court, Frank Murphy Hall of Justice? Or do you wish to adjourn the PCC? Those are your options this morning, sir. They're going to stay the same.
I would like for jurisdiction to be provided for the record, and that if not, I demand dismissal, for the record.
This case will not be dismissed, sir. Would you like the exam scheduled? Would you like to waive the exam, or would you like to adjourn the PCC?
Again, jurisdiction for the record. You cannot proceed without, when once jurisdiction is challenged, again, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That is Mello versus US.
Mr. Michaud, this is the last time that I will say this. I've indicated to you that this court is the 34th District Court, that this case is criminal in nature, and the allegation is that it occurred at Detroit Metro Airport, which is located in the city of Romulus. If there's something you wish to present, you may do so at the exam. You may present your motions at the exam date. So do you want an exam? Would you like the case to be waived? Or would you like to adjourn the PCC to confer with Mr. Sullivan?
No, I would like for this case to just be dismissed because the lack of providing a proper jurisdiction would make it seem like there's some secret jurisdiction being held against me without me knowing, and I don't consent to any jurisdiction that you have presented. I reserve all my rights, for the record.
Understood. And that being the case, Mr. Sullivan, is there anything you'd like to add, sir?
Judge, I don't know what to say. I'm not sure that that I still have authority to represent Mr. Michaud. I will say that Mr. Michaud has made his arguments, a couple times, and I think that the arguments have been, or the motions have been denied. And I've explained to him that those motions, his arguments are preserved on the record, and that he maintains the ability to appeal any denial of his motion to dismiss. He would be able to appeal that first at the circuit court level and then up to the Court of Appeals. So I've done my best to advise him of his rights to continue making that argument. I will also, I think the court may already be aware that Mr. Michaud is not in custody on this case. He's in custody on a contempt of court that Judge Oakley sentenced him to back at the end of January. So I don't know that there is, unlike clients that are in custody, a reason to expedite the setting of the preliminary exam. So I really, I want to defer to Mr. Michaud's stated interest, what it is that he wants to do with this case. I've given him advice, and I don't know what I can do beyond that. Again, I don't want to create any conflict in my representation.
Mr. Sullivan, the court wasn't asking you to. The court has heard Mr. Michaud's arguments. The record has been made. Your statements have been preserved, Mr. Michaud. And at this time, the court can do one of two things. We can schedule you for an exam next week. We have space available next Wednesday, the 28th. We can adjourn this matter for another PCC next Wednesday morning at 8:30, or you may waive your exam. Your response is one of those three things, please, sir.
Well, my response, I want to ask you a question. Are you honoring your oath to the Constitution today?
Yes, sir.
Okay, and I accept your oath, and upon you honor your oath.
Then Mr. Michaud, no. I've answered your question. I've now given you your options multiple times. The court has other cases. Are we scheduling an exam for next Wednesday? Are you waiving your right to have the exam? Or would you like another PCC next Wednesday morning at 8:30 so you have time to consider your options and how you will proceed in this case?
I demand a dismissal for lack of jurisdiction for the record.
Your request is denied, sir. The record's preserved. If you wish to appeal that decision, you may do so in writing properly filed. Again, exam, waiver, or adjourn PCC.
Dismissal for the record. I demand that you dismiss this you cannot move once jurisdiction is challenged, the court cannot proceed for the record, ma'am.
And Judge, for the record, the people would like to request a preliminary exam. There will be no plea offer. We did already have a probable cause conference in this case, so we are prepared to move forward, Judge, just for the record.
Marianne, is there space next Wednesday afternoon?
Yes, Judge, at 2:30.
I object. Court cannot proceed without jurisdiction for the record. Jurisdiction has not been provided for the record so that I may.
Mr. Michaud, the court has responded and provided the appropriate information to you. The exam will be scheduled for next Wednesday, February 28, 2024, at 2:30 p.m. in person here in courtroom number 1. If there is a motion that you want the court to consider, the court will take it up as a preliminary part of the exam.
I object.
Anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Michaud?
I demand for a dismissal for the record. Court cannot proceed without jurisdiction being provided for the record, and yet you still continue.
Your oral motion having been heard and denied. Anything else?
Why are you denying to put the jurisdiction on the record? Why? I just want to know why. Why are you denying?
I've done that, Mr. Michaud. I've done that. I've asked you multiple times how you would like to proceed with this conference. You refuse to answer the court's question regarding how we're proceeding. The prosecution has requested an exam. The court has scheduled an exam. If there are things that you wish to take up preliminary next Wednesday, we will take it up before the exam starts.
I'm not prepared. Do not wish to have a preliminary without me knowing how to defend myself under which jurisdiction. So it's still a violation of my rights, my due process. You're moving forward without telling me which jurisdiction so that I can properly defend myself and represent. Civil and criminal procedures have different jurisdictions, and I need to know which one are you operating up under now. How could you?
You do, Mr. Michaud. The court's answered the question multiple times, and the court deems this matter concluded. I will see you next Wednesday afternoon.
Check to that.
Your Honor, ma'am. Just for the record, his out date right now is February 24th. And if your clerk can send over paperwork, that way we have this case, this date and everything in the computer.
Understood, Marianne. We'll take care of it. Thank you. That concludes this matter, Mr. Michaud. I'll see you next Wednesday. You have a good afternoon.
Thank you, Judge, for your patience.
This is 230785FY. This is State of Michigan versus Daquan Evans. May I have your appearances, please?
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Evans, who's present via Zoom. Mr. Evans, can you please unmute and state your name for the record?
Your Honor, this is DeQuan Evans.
Thank you.
Thank you, Mr. Evans.
Yes, ma'am.
Today is a day and time scheduled for PCC in this matter. Ms. Phelps, the court has received from Mr. Mohammed an indication that count one will be amended from receiving and concealing stolen property motor vehicle to receiving and concealing under $1,000 with probation under HIDA plus terms and conditions set by the court.
That's right, Judge. And we are prepared to enter into that agreement today and would be requesting immediate sentencing as well, since it's a misdemeanor.
Mr. Evans, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You may put your hand down. Sir, you've had the opportunity to discuss this case with Ms. Phelps, and you understand the charges you face and the possible penalties.
Yes, Your Honor.
And after having that conversation, sir, is it your understanding and agreement that you'll be tendering a plea of guilty this morning to the amended count of receiving and concealing stolen property under $1,000?
Yes, Your Honor.
Sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes, Your Honor.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, Your Honor.
And sir, you're entering this plea freely and voluntarily?
Yes, Your Honor.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Mr. Evans, is it true that on September 14, 2023, I'm sorry. Ms. Phelps, before I ask him anything else, I want to disclose on the record that I'm married to an elected official in Van Buren Township. I make that disclosure as this event occurred in Van Buren Township. My husband is not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He does not know that Mr. Evans' case is scheduled. Do we need to pass this matter for you to confer with him, or are we prepared to proceed with the plea?
Judge, if I could just have a brief moment just to discuss that with him.
Absolutely.
Thank you. Yeah, and if we could have a breakout room, obviously. Thank you.
In the meantime, Mr. Mohammed, perfect. Mr. Martin and Mr. Harris, this is 240009FY. This is State of Michigan versus Christian Harris.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Judge Martin. Good morning to your staff. Neighborhood Defender Service, Carrie Martin, P84592. Up here on behalf of Mr. Christian Harris, who appears by Zoom. Mr. Harris, state your full name.
Good morning, Your Honor. Christian Harris.
Is it still morning? Good morning, Mr. Harris. Today is the day and time scheduled for the PCC in this matter. The court is in receipt of a plea form for Mr. Mohammed indicating that this case is being dismissed.
Yes,
I was not aware.
The people have decided to dismiss this case in regards to the pursuit or the interest of justice.
Mr. Martin, do you have any objection to this case being dismissed?
No, I do not, Judge.
That being the case, this matter is hereby dismissed. Bond in this matter was personal. Mr. Mohammed, anything else on behalf of the people?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Martin, on behalf of Mr. Harris?
Can I just confirm that all counts have been dismissed and there's no future misdemeanor court dates or anything for Mr. Harris?
That's correct, sir.
Great. Then nothing further. Thank you.
The only other thing, Mr. Martin, is that Mr. Harris has outstanding monies due to this court for a variety of infractions, including
Yes.
stop sign, failure to display, blah, blah, blah. He owes the court a total of $1,803. Mr. Harris, I need you to contact the court's collection department sooner rather than later. You may come in person, you may call and speak to collections, or you may go online and either remit payment or set a payment plan, okay?
Okay.
Other than
Thank
that,
you, Judge.
Mr. Martin, that concludes this matter. Mr. Harris, good luck to you, sir. You have a wonderful day.
You too. Thank you, Your Honor.
Thank you.
Bye, everyone. I'll see you later.
Yes, sir. We're back on the record in 230785, State of Michigan versus Evans. Oh,
It looks
what
like
happened to
he's
Mr.
stuck in
Evans?
I think he's stuck in the breakout room. There he is.
We're back on the record. Ms. Phelps, you've had the opportunity to speak to Mr. Evans. How are we proceeding this morning?
Judge, we're prepared to proceed. I explained what you just put on the record about being married to an officer in the Van Buren Township, and he's okay to proceed. I don't think there's any conflict.
He's not an officer. He's an elected official, just so the
Oh,
record's
I'm
clear.
sorry. I'm sorry about that.
No worries.
Yes, so we are prepared to proceed.
Thank you. Mr. Evans, my question to you was, is it true that on September the 14th, 2023 in Van Buren Township that you did receive and conceal stolen property that was valued under $1,000?
Yes, Your Honor.
Thank you. Ms. Phelps, the court will accept his plea of guilty to the amended charge. The court's only concern with immediate sentencing is that I'm not sure if there is an identified complainant or victim in this case that might wish to be heard in this matter.
Okay, then I think that is, I mean, it is a quote victim crime, so maybe they do need to give them an opportunity to appear.
Thank you. Then what we will do is the other parts of the plea agreement indicate probation under HIDA with any other terms. I'll send the file down to the probation department to get a letter out to the victim in this case to see if they wish to submit something in writing or appear. We have a March 4th probation date. I don't know if that allows sufficient time for that notice to get out. Mary Ann, I don't know, is that?
Let me check, Judge. What date are you looking at?
I'm looking at March the 4th. We have it as a probation date. I want to make sure that's sufficient time for probation to get notice out to the victim.
Give me 1 second. I will call down there.
Thank you.
April 8th, Judge.
April 8th?
Yes.
April 8th at 9 a.m.?
Yes, ma'am.
April 8th at 9 a.m. Notice will be sent to the victim for a victim impact statement or the ability to appear. Mr. Evans, notice will be mailed to you at the address that you verified with court staff this morning. Ms. Phelps, anything else on behalf of Mr. Evans?
Just for the April 8th date, is that still on Zoom for us?
Do you want it on Zoom?
Yes.
By Zoom.
Great, thank you. Then we will see you then.
Thank
Nothing
you.
else from defense.
I'll see you then. Thank you. Thank you for your patience this morning, Mr. Evans.
No problem.
And you're all good to log off, Mr. Evans. I'll give you a call in a minute.
Mr. Bickert?
Yeah, yes, Your Honor.
What else are you here for, sir?
Your Honor, I've been looking for Mr. Darnay Ventus, Ventus.
He was here with retained counsel this morning, Mr. Zelenak.
Okay, fair enough. And the only other thing I need to check with you, Your Honor, is there was a Mr. Sedlak. My understanding is that Mr. Sedlak, it's an older case. It's Miss Frederick's case.
Yes.
Yes, I want to check in on that as well. It's my understanding that I'm a little bit unclear as to the details of it, but that Mr. Sedlak was last in treatment in Ohio.
He was, and he is, and he logged on this morning, and Mary Ann could not get a hold of Miss Frederick. The matter was adjourned over. I just don't remember the date.
Okay, I can get the date. I apologize, Your Honor. I had logged on and then I logged off to do a sentencing that took very, very, very much longer than it should have, Your Honor. So I do apologize.
It was March 6th at 10 o'clock.
It was, yeah, it was interesting. So I do apologize, and so that's I'll get the date from your staff.
Mr. Bicker, should you be showing us the attorney of record for Mr. Sedlak going forward?
No, Ms. Frederick is going to keep the case. She'll be returning very shortly.
Okay.
So she's going to hang
Mr.
on.
Bicker.
Thank you, Your Honor.
Take care.
Take care. All right, you too.
Mr. Mohammed. Marianne, he gave me a file. I see you, Mr. Bassett. Give me 1 second.
No problem, Judge.
I don't know where Mr. Mohammed got this case from. It's not scheduled till next Wednesday, so we will put this on the side. 228. Hi, do you see Mr. Mohammed? I just need, yep, there's gonna be a waiver of exam. I just need his input. Thank you. This is 4S4328673ST, State of Michigan versus Olga Cruz. This case was scheduled for arraignment pretrial at 9:15 a.m. It's now 11:43 a.m. by this court's clock. Defendant having failed to appear, this matter will be set for show cause. This is 230-830-FY, State of Michigan versus Venetia Rains. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of people, P86771.
And good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Ms. Venetia Rains, who's also present by Zoom video.
Ma'am, unmute yourself and state your name for the record, please.
Venetia Rains.
Thank you. Today was the day and time scheduled for the preliminary examination in this matter. There is count 1, deliverer and manufacturer of a controlled substance. Count 2, use of computer to commit a crime. Are the people prepared to proceed this afternoon?
Judge, it's my understanding that the defense counsel has waived this exam, and so we are prepared. However, I did call up officers based off of that.
That's correct, Judge. I've advised my client of her right to an exam, Judge, and we're prepared to waive today, Your Honor, and have the matter bound over to circuit court.
Thank you. Ms. Rains, raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Ma'am, you've had the opportunity to discuss this case with your attorney. You understand that you have an absolute right to have a preliminary examination where the people would have to show that both a crime had been committed and that probable cause exists to believe that you're involved in the commission of that crime.
Yes.
And after having that conversation with your attorney, you wish to waive your right to have that examination.
Yes.
And ma'am, you do so freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to waive the exam?
No.
You understand that once this exam is waived, the next step in these proceedings is that you will be bound over as charged for an arraignment on the information at the Frank Murphy Hall of Justice.
Yes.
Mr. Besant, because you appear on Zoom, there is not a signed waiver in the file. Do you authorize the court to sign the waiver on your behalf and on behalf of your client?
We do. No objections to the signage, Your Honor.
Any objections, Mr. Mohammed, to the waiver of the exam?
No objection, Judge.
Thank you. That being the case, the court will execute the waiver. Ms. Raines, you will be bound over as previously charged. As indicated before, the arraignment on the information will occur at the Frank Murphy Hall of Justice. That will be on March the 6th, 2024 at 9 a.m. The previously entered bond with any of its conditions will continue. Mr. Mohammed, is there anything else on behalf of the people?
Nothing from the.
Anything else on behalf of Ms. Raines?
Nothing from the defense counsel. Thank you, Your Honor.
Thank you. That concludes this matter. Ms. Raines, you're free to go. Good luck to you. Have a good day.
You.
Thank you. He can if he wants to.
Say it's good.
Okay. Two S 3999353 SM, State of Michigan versus Dynamic Transport. This case was scheduled for show cause arraignment pretrial at 10 a.m. It's now 11:47 a.m. by this court's clock. Defendant having failed to appear for a second time in this matter, bench warrant shall issue 5,010%. Yes. And this court's next matter being scheduled at 12 p.m. We will stand in recess until that time.
Are you taking it, do you want me to take it down or are you leaving it up?
Leave it up. We have exams that are scheduled. We have an exam that's scheduled at noon.
I see your lips moving, but I can't hear you.
We have an exam at noon, so leave it up.
Okay.
Thanks.
Yep.
I don't think before. So maybe when she comes out, and the prosecutor's here, yeah, I think that was you guys, yeah. Yeah, yeah, sure.
How are you? Good.
All right.
You may be seated. This is 230665FY, State of Michigan versus Clark. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Good afternoon, Your Honor. May it please the court, Teresa Sabrina, P84945, on behalf of Aiden Clark, please seated to my left. Mr. Clark, please state your first and last name for the record.
Aiden Clark.
Thank you. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, possession of controlled substance being methamphetamine or ecstasy. Are the people prepared to proceed?
Yes, Judge, the people are prepared to move forward.
Defense prepared to proceed.
Yes, Your Honor, I would just have a preliminary question if me and the prosecutor could approach briefly. It sounds like there may be a situation. I just didn't know what the consideration for purchase of this. It would be something that I'd like to do. It's something that you watch.
What's kind of long there is a 20-year-old kind of long is 15 minutes for long for me for 6 hours. So what is it?
Yeah, it's probably more.
I didn't know that that's small here.
It's the, I mean, it's the entire, I guess we could limit it. I guess the problem is with the contact of the testimony, I think we need to.
Our next case isn't scheduled until 1 o'clock, so if we want to watch it, we can watch it. Doesn't matter.
I'll stick with it. It's up to the judge.
I'll watch whatever you want me to watch. Don't. Are you plugged into our system?
I would try to limit it though to what it is.
Can you do that? You already know where.
I have to double check the timestamp, but I'm familiar enough.
Okay.
I think I can move it.
Okay. You can HDMI cable, not HDMI cable, is that what it's called? Into our system. If you, I don't know what your technology is, we can do it that way, and show them all the screens at the same time, and you can move forward to whatever it is you want me to see, or I'll watch as much of it as you want me to watch. Okay. Doesn't matter to me. I guess I just want to make sure connection wise, yes.
We do. Yep, it appears on all the screens and all the tables, and if for some reason you can't connect through cable, I'll just have you run it through Zoom on a screen share. Okay? Is there something else?
No.
Okay. Any preliminary matters, Mr. Mohammed?
Yes, Judge, two. I would like to request a mutual order of sequestration with the exception for the OIC who's sitting here to my left, Officer Struttengoss.
Request granted. Any other preliminary
And
matters,
then the
Mr. Mohammed?
second Judge, and just for the record, Officer Adams is here as well. He may be called as a witness. And then the second judge is pursuant to 76611B. It's the MSP lab report that shows that the drugs recovered in this case were indeed tested positive for methamphetamine.
Yes, sir.
I did show this at the time.
Thank you. Yes, sir. Any other preliminary matters, sir?
Nothing from the people.
Any preliminary matters, ma'am?
No, Your Honor.
That being the case, Mr. Mohammed, your first witness, please.
Judge, the people call Officer Struttengoss to the stand. Struttengoss.
Have you stop right here? Spell your first and state your name for the record, and then spell your first and last name, please.
My first name is Todd, last name is Schreckengost, SCHRECENGOST.
Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Please come have a seat in this black chair that's closest to me. Mary Ann is recording your testimony. If for some reason she can't hear you, I'll ask you to either raise your voice or scoot closer to the microphone, okay?
Yes.
Thank you.
Good afternoon, Sergeant. Can you please restate your name for the record?
Sergeant Todd Schreckengost.
Sergeant, are you currently employed?
Yes.
And who is your employer?
City of Belleville Police Department.
Okay, and in what capacity are you employed there?
Currently a patrol sergeant, supervisor with the department.
Okay, and how long have you been working for the Belleville Police Department?
About 24 years.
And did you work on the date of December 30th, 2021?
Yes.
And were you by yourself on that? Were you employed in this capacity on this day?
Yes.
As a police officer? Okay.
Yes.
And on this day, did you work by yourself or with a partner?
I was in a single patrol car. There was two other officers that were on duty that night.
Okay, and what other officers responded on that day?
Be Officer Adam and Corporal Matthew Vandewey.
Okay. Okay, on this day of December 30th, 2021, did you work on foot patrol or in a scout vehicle?
I was in a patrol vehicle.
Okay, is that scout vehicle fully marked or semi-marked?
It's fully marked, both sides and overhead lights.
Okay, and on this day, were you in full uniform or modified uniform?
I was in full uniform.
And did your duties on December 30th, 2021 take you at or near the location of 300 block Main Street?
Yes, I was in the 300 block of Main Street, routine patrol.
Okay, is that in the city of Belleville, County of Wayne?
It is.
Okay, and while at or near that location, what, if anything, did you observe?
Observed a vehicle, I believe it was an Impala, and it was parked facing southbound in the on-street parking, curbside parking within the roadway of Main Street in the 300 block.
Okay, and what about this Impala drew your attention?
The time of night that it was parked in front of some closed businesses, it was around 2:15 in the morning. And it was running with the headlights on as if it was to pull away.
Okay, upon this observation, was there anything else about this observation that drew your attention?
Yes.
What is it?
Appeared that there was a subject that was in the driver's seat or in the front seat of the vehicle. However, the windows were extremely tinted dark. Only thing I could see was like a silhouette backlit from the businesses that were behind it, on the side of the vehicle.
Okay, and you stated you observed an individual in that vehicle?
Yeah, it appeared to be hunched over to the right.
Okay, what do you mean by hunched over?
Not in a normal seating upright position like you would normally drive a vehicle somewhere someone slumped over the wheel.
Okay, so was he hunched over the wheel or just hunched over to his side?
Hunched over to the side, he wasn't moving.
Okay.
But I didn't really see it until I actually went around the block and circled behind the vehicle.
Okay, and upon that observation, what if anything did you do?
Once I went around the block, once I observed the vehicle, I went through the alley and up around and came behind the vehicle and parked behind it. And then I
Okay.
got out of the patrol car and approached.
Prior to getting out of the scout vehicle, did you initiate lights or sirens?
No,
Okay, so after approaching this vehicle, which side did you approach?
I believe I put my spotlight on, but other than that, I didn't turn on any overheads or anything.
Okay, which side did you approach?
Driver's side.
Okay, and what did you do when you approached the driver's side?
Then I got closer, I could see that there's obviously somebody in the vehicle. And I began to knock on the windows and the door, knocking on the side of the window to get his attention or the person's
Okay.
attention.
Prior to knocking, you said you observed an individual in the car.
Yes,
Where was that individual seated?
in the driver's seat.
Okay, and what was that individual doing, if anything?
Appeared to be sleeping or passed out.
Okay, and just to confirm, I think you mentioned earlier the vehicle was running, correct?
It was.
Okay, now upon observing that, what, if anything, did you do?
Radioed for another unit to arrive to assist.
Why did you do that?
In my experience, it's mostly an intoxicated driver or someone like that. And sometimes when you arouse the person or something, they try to attempt to drive off, or they get startled, or they become combative. I just wanted to make sure I had another pair of eyes there and assistance in case I needed it.
Okay, did you attempt to make contact with the driver of the vehicle?
Several times.
How?
Shining my flashlight through the window into the individual's face, shining it through the front windshield. Could not get a response from him at all. He was completely.
Did you do anything else to try to make contact with this driver besides shining the light?
Yes, we were tapping and beating on the window very loudly.
Okay, and did that draw the driver's attention?
It did not.
Okay, and then so what occurred next, if anything?
Officer Adam and Corporal Van de Wey arrived on scene, and I instructed Officer Adam to retrieve a lockout tool.
Why did you do that?
We've had numerous drug overdoses and similar events occur. Well, I wasn't sure whether the person was intoxicated or whether it was a drug overdose or if it was something medically issue that needs to be addressed.
Okay, so you mentioned that you indicated to Officer Adam to do what exactly?
Get a lockout tool, which is basically a Slim Jim.
Okay, and what occurred next, if anything?
I utilized the Slim Jim and opened the driver's door.
Okay, now upon the driver door being open, how many occupants in that vehicle did you observe?
Just one.
Okay, and where was that individual sitting?
In the driver's seat.
Okay, that individual that was sitting in the driver's seat, can you describe what you observed?
Believe he had like a hoodie sweatshirt on.
Not necessarily what he was wearing, but what he was doing.
Absolutely nothing. He was passed out.
Okay.
Appeared to be unconscious. He was either sleeping or unconscious, one of the two.
That individual, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
That's a gentleman with the beard and the long trench coat that's sitting next to.
Can you please point to that individual for the record?
He's sitting right there.
Your Honor, please let the record reflect the witness has pointed to and identified the defendant.
Yes, sir.
Thank you. And how did you attempt to make contact with this individual when this door was open?
I yelled, hey, trying to get his attention. I actually shook him a couple times on his shoulder.
And did he respond when you shook him or said, hey?
He did not initially, no.
Okay, and then so upon him not responding, what, if anything, did you do?
And then we suspected that it might be an overdose of some type. At that point, he started mumbling.
What did he mumble?
Something to the effect of, I'm coming, honey, or hold on, baby, or something like that. If I can refer to my report, I can probably give you exact quote of what he said.
Your Honor, may I approach the witness for the copy of this report?
Yes, sir.
Please refer to your report and refresh your recollection. When it's completed, please look up at me. Okay.
He said, I'm good. Come on, honey.
Okay.
So I'm good. And he kind of threw his arm up like, and I'm assuming he was referring to a female of acquaintance of his that he thought was trying to awaken.
Okay, and that driver, what was his demeanor like throughout this interaction? How did he appear to you?
Lethargic, disoriented, confused, not really sure what was going on.
Okay, and based on those observations, what, if anything, did you do?
It was cold that night. Once I opened the door and woke him up a little bit, kind of opened his eyes up, and I told him it was the police. And he looks down and he goes, "Oh shit."
Okay, and what occurred next, if anything?
Had him exit the vehicle. He needed some assistance kind of getting out. He's kind of unsteady on his feet, disoriented.
And why did you have him exit the vehicle?
I just wanted to get him away from the car so that, because it was still running at the time, I didn't want him to regain enough consciousness that he would think about trying to drive away or drive off.
Okay, so then what occurred next after you asked him out of the vehicle?
I walked him back to our patrol vehicle.
Okay, and then what occurred next, if anything?
I told him I didn't really smell any odor of intoxicants or alcohol on his person. So I suspected that it might have been either drugs or if he was just tired and went to sleep or not. I wasn't sure.
Okay, and so what did you do next?
I detained him for safety of the fact that we were on the roadway and that he was kind of disoriented still. He wasn't really with it per se. And so that he was detained for possible possession of narcotics.
Okay.
Or driving under the influence.
And then after that, what, if anything, occurred?
I sat him in the patrol vehicle and I spoke to him for a little bit, and we had a little conversation about where he was coming from and where he was going to and what he did for a living and those type of questions.
Anything else in regards to your investigation?
I asked him if there was any narcotics in the vehicle or anything like that. He said no.
Okay.
And then I asked him if we would mind if we took a look inside his vehicle. He said sure.
Okay. And upon getting that information, what, if anything, did you do?
Officer Adam approached. I informed Officer Adam that we were having a discussion about what was going on and that he gave permission for us to look inside his vehicle.
Okay, and then what occurred next?
Officer Adam proceeded to do a precursor inventory or a vehicle search of the vehicle, consent search.
Did you personally observe Officer Adams recover anything?
I observed him remove several items from the vehicle.
Okay, and did you observe any of those items?
Yes.
What items did you observe?
He brought, initially he brought marijuana. There's a jar of marijuana and some other things from a dispensary from Ann Arbor. And then he also brought out a small Tupperware dish.
I'm sorry, a
what?
small.
Tupperware dish.
Thank you.
In this Tupperware dish, what was the reason it was recovered, if you could?
Officer Adam said that he found like a off-white crystal.
Okay. I agree, it is.
So rephrase your question, Mr. Mohammed.
Yep.
Thank you.
Officer Adams, did you observe anything in regards to this Tupperware personally?
I did. That Officer Adam brought it to me, yes.
Okay, and please don't testify to anything Officer Adams says. That would be considered hearsay. You can only testify to what you saw, what you did.
Yes.
Okay, so did you do anything personally?
Yes, I took possession of the Tupperware dish from Officer Adam.
Okay, and what did you do next?
I observed inside an off-white crystalline substance.
Okay, upon making that observation, what, if anything, did you do?
Based on my training experience, I believe that it was the item that was in the Tupperware dish was methamphetamine. I instructed Corporal Vandewey to go to our station and get a NICS chemical test kit.
To get a what?
A NICS chemical test kit for a drug test.
Okay, and what occurred next?
Officer Vandewey left and then returned shortly with the NICS kit.
Okay, and how are you associated with the NICS kit?
I used that to identify substances on the street as a
Okay.
preliminary test.
And did you do that preliminary test in regards to this crystal-like substance you observed?
I did.
And what was the results of that test?
It was a presumptive positive for methamphetamine.
Okay. You mentioned the defendant gave you consent, correct? Or something along those lines where he allowed you to search the vehicle, correct?
I asked him if we could look inside his vehicle. He said, sure.
Was this vehicle towed?
Eventually, yes.
Why was it towed?
It was removed because it was in a roadway that the vehicle was unsecured. The vehicle was running. It did not belong to the defendant, or it wasn't registered to the defendant, that I believe. And that there was no licensed driver that could take possession of the vehicle at the time.
Nothing further from this witness, Judge.
Thank you. Your witness, ma'am.
Is that correct?
Yes.
Okay, my name is Parisa. I represent Mr. Clark.
Hello.
How are you?
I spoke to you on the phone a couple times.
Yes, how are you doing?
All right, how are you?
I'm all right. I'll be asking you some questions. I call for a yes or no question or a yes or no response. If you don't understand my question, if you need me to rephrase it, just ask me, okay?
I'll try my best.
Okay. So you went to the police academy.
I did.
You were taught to write reports.
Yes.
You were taught to write complete reports.
Yes.
You were taught to write thorough reports.
Sure.
I'm sorry.
Sure.
You were also taught to write neutral reports.
Yes.
The way you wrote them then is the same way you write them now.
I'm gonna object, Judge, it's irrelevant.
Objections overruled. You may answer the question.
Which time period you were speaking of?
I'm just saying the way you were trained to write police reports, the way you did train back then is how you write your reports now.
Correct.
You understand that your reports can be submitted to a prosecutor's office.
Correct.
And based on a report, a prosecutor can make a charging decision.
They could.
And that's exactly what happened here, correct?
Not sure what all went into the charging decision.
And I'm gonna object, Judge, to speculation.
Well, Mr. Clark was criminally charged, correct?
Is my understanding, yes.
And you wrote.
I'm
the-
sorry, your objection was to
It was
speculation and you didn't respond. Did you want to respond to the objection?
Your Honor, I'd rather just, I guess I could rephrase the question. I mean, if that would be okay.
That's fine.
Okay. Are you aware that Mr. Clark was criminally charged?
Yes.
And you wrote the report in this case?
Yes.
And that's the report ending in 3527-001?
I'd have to look at the report to see if that was correct.
May I approach, Your Honor?
Yes, ma'am.
The witness copy of the report. You should just take a look at that and tell me if that reflects your recollection.
Yes.
May I approach the witness?
Yes, ma'am.
I'm retrieving a copy of the report. And I'm sorry, so the report number was 3527-001.
Correct.
And this report is a truthful and accurate representation of what you witnessed on December 30th of 2021.
Yes.
You reported everything that points to any evidence that you saw or observed on that night.
Can you say that again?
You reported everything that point, all the evidence that's relevant to guilt or innocence in this case.
Define record.
You wrote it in your report.
Yeah.
You did your best to include all the information.
Not sure what you're referring to other than that was what I observed.
Okay. And you reviewed your report prior to testifying today?
I did.
You discussed the contents of your report with the prosecutor?
I did.
Is there any changes that you wish to have made to your report at this time?
No.
So on December 30th of 2021, you were patrolling the area of Main Street and 3rd Street, correct?
December 30th, you said?
Yes.
Yes.
And that was approximately around 2:15 in the morning?
Yes,
It was dark?
it was.
Okay. While you were, and you had an unobstructed view of that Chevy Impala, correct?
At what time?
When you first observed it?
I was in a patrol vehicle driving past, so yeah. I mean, I guess it was somewhat of an obstructed view. The windows were tinted. That's what you're getting to.
So when you first drove by, you just saw a running car with headlights on?
No, I saw someone that looked like it was a figure in the, or something in the front seat of the vehicle. I could see a silhouette. I couldn't tell if it was a person or if it was items or what, but there was something in the front seat of the vehicle.
And the vehicle was parked on the side of the road?
It was.
Okay. It was a designated parking area?
It's a curbside parking.
So other cars could park there?
Yes,
And then you proceeded, it sounds like, did you proceed to drive past the Chevy Impala?
I did slowly.
Okay. And when you did that, did you make a turn around the northbound alley to come up behind the vehicle when you parked?
I actually turned west and then came up to the east and then we came back southbound behind the vehicle.
Do you know how far of a distance that was?
Not more than, I mean, just one building.
Are we talking about, how long did it take you to do that?
Maybe 30 seconds, if that.
And when you pulled up behind the car, that's when you activated your overhead lights?
I didn't have overhead lights on. I used my spotlight.
And I'm gonna object, Judge. That question was never answered in that way. It's kind of like a misrepresentation. In regards to the lights being initiated, I don't recall this witness ever testifying that he initiated lights. I think I recall when I asked him that question, he said he didn't. And he just approached the vehicle and then put on like his spotlight inside of the driver's vehicle.
That's what he said during direct.
Yeah.
Yes.
That was my understanding.
Yes.
I think the question that was asked said when you turned on your traffic lights, and I don't think they were ever initiated. So that's the only reason for my objection, Judge.
Your objection is her mischaracterization of his direct testimony.
Correct.
Your Honor, I guess I was just asking a question whether or not he activated his overhead lights at the time that he pulled behind the vehicle.
I understood. You may answer the question if you recall the question.
I did not activate my red and blue lights, my overhead lights on my patrol vehicle. It was just a spotlight on the driver's side.
At any point, did you activate your overhead lights?
I might have turned the rear flashers on eventually once we determined that we had a scene here, something that was going on.
Okay.
But initially, no.
And now you decided to get out of, To search, or not to search, strike that, Your Honor. To approach that vehicle, were you doing it because of a welfare check? Or
Wasn't sure what was going on.
it wasn't for any sort of like civil infraction or anything? that you
No, it was a
observed?
suspicious vehicle. I mean, the businesses were closed. It's 2 o'clock in the morning on a holiday weekend, or beginning to be a holiday weekend of New Year's.
And eventually you shined a flashlight through the window of the
Several
driver's side
times.
car.
Yes,
And that's when you saw an individual in the vehicle?
I confirmed the individual in the vehicle, yes.
Okay. And he appeared to be sleeping?
Sleeping, passed out, unconscious.
You
Not
saw him
sure.
breathing though?
He was breathing, yes.
Okay. Other than seeing him sleeping, you didn't see any other sign of distress, did you?
Not necessarily, no.
You didn't see white foam around his mouth?
Not that I could tell. I mean, he was kind of slumped over, so I couldn't really see his face.
Okay. You didn't see any vomit?
Couldn't tell that it was too dark in the windows.
Didn't see any blood?
Not, no.
Okay. You didn't see him convulsing in any way?
No, he was totally unconscious.
You also observed that the car was actually in park, correct?
It was running, yes.
And then by this point, you had called other officers to arrive on scene,
I did,
and that was for assistance?
yes.
So was there a total of 3 cops there or 4?
It was 3.
Based on your knowledge, all officers were in uniform?
They were,
They were also arrived with their patrol vehicles?
correct.
Do you recall seeing overhead lights from their other vehicles?
I don't recall.
And now, during this investigation, did you activate a body worn camera?
Yes,
Would that camera footage accurately depict what you observed on December 30th of 2021?
it would have recorded the events, yes.
Okay, Your Honor, I would move for the admission of defendant's proposed exhibit A, which is the body worn camera evidence.
No objection.
It will be received. Now, ma'am, again, is it your intention to play it in its entirety, or have you queued it up to the part that you think is relevant to your cross-examination of
Your-
Sergeant?
Oh, I'm sorry.
Mm-mm.
With respect to what occurred on direct, I think I need to expand the footage. I don't think it would be limited to just,
It's fine.
No objection.
I don't know, Your Honor, if you prefer to play it at the end. If that's
Your,
okay.
your representation, you proceed how you please.
Thank you, Your Honor. And now you instructed another officer to retrieve a lockout tool.
Correct.
Now, is it fair to say that you didn't knock on Mr. Clark's driver's side window at first? Or at what point did you do that?
No, we did several times.
Did you do that before or after you attempted to use the lockout tool?
I know we did before, because when we walked up to the vehicle, we're trying to get his attention and he didn't respond.
If the body worn camera doesn't show that you knocked first, would you dispute that?
I maybe possibly, it's been 3 years ago. I don't know if I did it before or after. I know that I did knock at one time. Or somebody did.
Well, is it fair to say that the first time you tried to use the lockout tool, you were not successful with it?
I don't recall.
At some point, you were able to successfully open Mr. Clark's door.
Yes,
Again, you saw him sleeping.
yes. Or unconscious.
And at that point, you had a.
I mean, he's not responsive, unresponsive.
But at that point, you could see him clearly. There was no tinted window in front of you, correct?
Say that again. You said it was open already.
So the car door was open. You had a direct view of Mr. Clark.
I did.
You didn't see, again, at this point, you didn't see any white foam in his mouth.
Oh, he tried to initiate a response from him.
You didn't see any white foam though around his mouth.
I'm gonna object to the white foam line of questioning, Judge. I believe that question's been asked and answered multiple times.
Your objection is overruled. I think she's asked at different times.
Correct.
in Sergeant's interaction with Mr. Clark.
Okay, I withdraw my motion.
You didn't see him at that point convulsing in any way.
No,
You didn't see any vomit at that point.
not that I was aware of, not that I recall.
Okay. And then it sounds like at some point you grabbed him to try and to wake him up. Is that accurate?
Yeah, I shook his shoulder. Yeah, I wouldn't say grab him.
Okay. And you ordered him out of the car.
Eventually, I asked him from the vehicle, helped him out.
On direct, you had indicated that you had asked him to be removed because you were concerned about the car that was running. Correct?
Yes.
Okay. Now, with respect to your police report, it's my understanding that you had removed the keys prior to that.
I think prior to him waking up, mostly, I don't know if it was myself or it was another officer that reached in and turned the keys off.
Okay. So by the time Mr. Clark exited the vehicle, the car was off.
Around the nearly the same time that he was being removed, the vehicle was turned off at one point. I don't know if it was right before or right after.
And I'm sorry, and I may have missed it on direct. What was your purpose of instructing him out of the car then at that point?
Just to determine whether he was, I didn't know what was in the vehicle, whether he had access to a weapon or drugs or anything else that he was trying to that he may have tried to attempt to dispose of or have access to. Wanted to get him away from the vehicle so that he didn't attempt to restart it or drive away, which he did at one point, like kind of come to and want to start the vehicle or get into put the vehicle in gear again.
But you had you had taken the keys from the car though, correct?
I don't remember if I was the one that actually took the keys from the vehicle or if it was another officer that reached in and grabbed. I don't recall.
And you had testified that Mr. Clark appeared disoriented.
Yeah.
Okay. Isn't it possible that he appeared disoriented because he was just woken up?
Yeah, he made several statements as to that I was a female or.
Is it your testimony that you believed he was under the influence of something?
Possible.
And then you immediately handcuffed him.
I did.
Okay. You asked him if he was sleeping out in his car. Do you recall that conversation?
I remember him saying that he was extremely tired, that he had been through a lot. And then he asked me several times not to arrest him. He was crying. He said that his mom was ill. We had several discussions.
Okay. While he was handcuffed, you performed a search on his person, correct?
I handcuffed him and pat searched him before placing him in the back of a patrol vehicle, yes.
Okay. You found no weapons, correct?
I did not.
You found no contraband on him, did you?
Not that I recall.
You did retrieve his wallet though, correct?
Possibly.
You told him that you were actually going to, you verified his license at that point.
I don't recall. I mean, in the normal procedure of a traffic stop, yes, I would verify a driver's license.
And you've arrested dozens of individuals for suspicions of OWIs or possession cases, correct?
Possession of narcotics, driving under the influence of narcotics.
You're trained.
Sleeping drivers do.
Okay. You're trained to look for clues of signs of impairment or intoxication,
Yes.
correct? Okay. You look for, I don't know if you object to my compound question, but you look for glossy eyes, bloodshot eyes, slurred speech, and things like that.
No, judge the speculation.
Objection is overruled. You may answer the question.
In relation to impaired driving, yes.
Okay. It's fair to say you didn't observe any slurred speech from Mr. Clark once you had him removed from the car.
I don't know about slurred speech, but I know he was lethargic.
Well, so you would agree with me that lethargic is not a clue for impairment or intoxication.
It can be.
You didn't observe any dilated pupils.
Not that I recall.
You were able to ask Mr. Clark questions.
Yes,
Okay. You understood his responses once he got out of the car.
for the most part, yeah, when he was crying and talking about his mother and stuff like that.
And in this case, you didn't perform any sort of standardized field sobriety test.
No,
And at some point, while you had him handcuffed, you escorted him to the back of his car, correct? On the outside.
if I recall correctly, maybe, I don't know.
He didn't lean up against you, did he?
I don't remember.
You don't recall him having to lean against the car for balance or anything like that?
Not that I recall.
And then, while still handcuffed, you placed him in the back of the patrol car.
Which, when initially or at any time? I mean, you
Initially
jumped
when-
from between the vehicles after I removed him from the car.
After you moved him from the car, you placed him in the back of your patrol vehicle.
I did.
Okay. And he was still handcuffed at that point.
Yes, he was handcuffed, yes.
Okay. Mr. Clark wasn't free to leave at that point.
He was not.
Okay. When you put him in the back of the patrol car, do you recall whether or not you locked the back doors or not?
The back doors to patrol vehicle,
Yes.
they automatically lock. There's no access from the inside.
Okay, so you wouldn't have been able to leave the car.
No, I told him he was detained for possession of narcotics or suspicion of narcotics.
And to your knowledge, were there patrol vehicle lights that were on during this time?
There may have been rear flashes or something to notify the motoring public that we were on the side of the road.
When you were in the patrol vehicle with Mr. Clark, there were still two other officers on scene? Initially,
Initially, there was 3 of us, yes.
okay. And then while Mr. Clark was handcuffed in the back of your car, the 2 other officers were still on scene?
I don't know if I don't know if Corporal Vandewey was there or not. I know Officer Adam was because I instructed him to conduct a search of the vehicle.
And now, while Mr. Clark was in the back of your patrol car, you asked him questions?
General questions of where he was going to and from, and what he did for a living. He told me that he was a semi-driver for PepsiCo, I believe.
You also discussed with him the possibility of arresting him for OWI. Isn't that correct?
I don't recall that.
If that shows on the body worn camera, would you dispute it?
I think it was in context of a conversation as to why I stopped him or why he was sleeping on the side of the road.
Well, initially you had said you had detained him for narcotics, for
did.
suspicion of narcotics.
We told him that.
Okay.
I didn't smell alcohol or intoxicants on his breath or on his person, so.
You then asked him to search his car,
I did.
and there was a consent to that search?
Yeah, I asked him, can I look in the car? He said, sure.
So while he was in the back of the car, you asked him questions
About
about what he was doing that evening, correct?
where he was coming from, what he did for a living, why he was so tired, because he kept saying, I'm tired, and
While he was in the back of the park, of the patrol vehicle, you asked him questions, you
Mhm.
observed his mannerisms, and then you asked him to consent to a search to the car,
Mhm.
correct? You would agree with me that all of that could have been done while Mr. Clark was sitting in his own car.
yeah, we didn't know what was in the car. That's not a safe place to be.
You would agree with me that you could have done it outside of your patrol vehicle.
Yeah, it was about, I believe it was like 10 degrees that night.
Okay. I know it was cold, but you still could have, correct?
Could have, yes.
Now, when you asked about the search, you actually had to ask him twice. Do you recall that?
I don't recall that.
And he actually said his response was, no, sir, wasn't it?
No, I don't recall that either.
Okay. If the body worn camera shows that, would you dispute that?
I wouldn't dispute it one way or the other. He said, sure.
While Mr. Clark was in the back of the patrol vehicle, you had told him that medically he's okay. Do you recall that?
No.
Again,
No,
if that-
Judge, just assuming that's not evidence.
Well, here's, I'm not ignoring, your response to his objection.
Your Honor, originally the officer testified that there was a potential medical crisis.
Respectfully, ma'am, here's the part of the thing. There's a video that you want to play, and I believe that your questions are premised on what's in the video. And you're asking him about things that happened in December of 2021, and he says he doesn't recall, then you'll play the video and then we'll come back. Maybe it's time to play the video.
I only have a few more questions, Your Honor. I can move along and then play the video. if that
Okay.
makes sense.
So his objection is sustained because his objection is sustained. If you want to move on to your next question, please.
Okay. I only have one more question for you. During the entire stop and investigation, you did not ever contact any sort of emergency services, did you?
Objection, asked and answered. He did testify that he contacted other officers. And if she's referring to like an ambulance, that's assuming facts not in evidence.
Your objection is overruled. Sergeant, you may answer the question if you recall the question.
Can you ask that one more time?
During the entire stop and investigation, you did not ever contact any sort of emergency services, like an ambulance.
Not that I recall. I believe he was pretty coherent once he woke up.
Your Honor, may I just have 1 minute?
Yes, ma'am.
Your Honor, at this point, I would like to publish the video.
Yes, ma'am. Are you plugged in over there already?
I believe so. I just don't know if it is correctly, but I will do my best.
If you're plugged in, it should start showing. Is it up on your screen? It's up. That is what your laptop looks like, correct?
Yes.
Okay.
Do you see I have the video up. Do you guys see the video on your?
I don't. What I see is what's on the screen right now.
For some reason, Your Honor, it's showing on my laptop, the video, but it's not showing on the HDMI.
I don't know why it's not. You call for it, please. Because this happened last week. What did he do to fix it last week? Do you remember? Hmm? It's running on your laptop right now.
Correct, Your Honor. Your Honor, I'm sorry, may I have your Zoom meeting name?
It's 580-707-8882. Here's the, Mr. McAnally. She's plugged in and it's running on her screen, but we can only see her screensaver, not what she's running. Thank you, Fred. No worries.
Now, the video from this body camera is about 45 minutes.
What happened to 20 minutes?
I said it was more than 20 minutes.
More than 20 minutes. Ah.
The judge, just so I understand it correctly, we're gonna watch the full 45
We are
minutes?
not. Exam means, preliminary exam is shortened to the point. So let's get where you start playing it and we'll see what happens.
I don't think the audio comes on for, I believe there's a 30-second delay. Excuse me, Your Honor. I'm sorry, are you guys able to, just want to make sure everyone's good?
Yes. Ma'am, is there something specific that you want us to view?
Your Honor, some parts of this beginning and then with respect to the initial contact with him, and then most likely leading up to him in the back of the car.
And Judge, I just would like the record to reflect that lights, the siren, the police lights turn on after he's at that door talking with other officers. It wasn't on initially.
Hold on back here for a second. Stand right here.
Would you pause this, please? Now, before the exam started and I asked about the video and we didn't agree on what the timeline was. Was it 20 minutes? You said now 45 minutes. This is preliminary examination. I asked you to cue the video up to the part that was relevant, pertinent, important. When we schedule these exams, they're scheduled for half-hour blocks. They've been half-hour blocks in this courtroom for the 3 years I've been on the bench. Are we getting specifically somewhere? Do you want to fast forward to something that's pertinent to the possession of methamphetamine or ecstasy?
Yeah, with respect to the consent, yes, I was just finishing up this and I was gonna move it for that clip. And then
Okay,
that's all.
let's go. Yes. My question to you is what is it that you want to show? What are you getting to?
With respect to the consent of the search warrant. That would be all, Your Honor, unless the court would be inclined to see more.
Did you have some other questions for Sergeant?
Can I just have one moment, Your Honor?
Absolutely.
Now, based on watching that footage, with respect to your earlier testimony, you had indicated that you had instructed another officer to search for narcotics. Would that still be the case?
I didn't tell him what the specific look for, no.
The video indicated that you asked him to search for open intox, right?
That's different than narcotics, but yes. I asked him if he had any open intox, and I asked him twice where he was going to. And then I asked him if he had any open intox in the vehicle, because he was asking about his driving record and his OWI. And then he also asked, I said, do you mind if I take a
I'm
look?
gonna object to that, the question, Judge. It's not, I understand I don't really think it's relevant enough to be asked. And the reason is, operating while under the influence, that could come from drugs or alcohol. It does not have to come from just alcohol. So whether or not he's telling his colleagues to search because he's under the suspicion that this individual is, potentially under the influence, whether it's drugs or alcohol, that part is irrelevant, I think.
So your objection is not that her question is irrelevant, is that she's narrowed her question specifically to open intox is irrelevant?
Correct, Judge.
Objections overruled.
And based on the review of the footage that you've seen that thus far, you'd agree with me that there's no discussion necessarily of narcotics, is there?
I don't recall what the discussion was about. I know that we did have a discussion about narcotics once they were located in the vehicle.
But before then, there wasn't.
I had my suspicion that he was under the influence of narcotics because I didn't smell any alcohol or intoxicants on this person. So I didn't give Officer Adam any specific instructions as to what to find. I just asked him to search a vehicle.
With respect to the video that was played earlier, you would agree with me that you had mentioned the word that he was drunk, correct?
He was unsteady on his feet and wobbly.
I'm referring to
I never said he was intoxicated.
You didn't hear that on the video that I just played, that you had mentioned that he was drunk.
No, I remember the conversation now that he was asking about his driver's license. And I said, well, if I arrest you for OWI, yes, or driving while under the influence, which could mean drugs or alcohol, or both.
I have no further questions, Your Honor.
Thank you. Any redirect?
Yes, Judge, I'm trying to keep it brief. Sergeant, you initially mentioned that when you first approached, you observed an individual in the vehicle and you left that location, you made a turn around and you came back to that vehicle, correct?
Yes.
Why did you come back?
Because I observed what I thought was someone slumped over in the driver's seat of the vehicle, but I couldn't tell for sure. Just driving by.
Okay, and when you approached that vehicle, why did you open the door?
If you watch the video, you can actually see me knock twice on the window. And you can see the other officer shining flashlights in the window. So I attempted to arouse the driver, which was unsuccessful in doing. That's why I opened the door.
I understand. Why did you open the, why did you want to open the door?
To make contact with him to ensure that the driver was okay, or if he was not overdosed or intoxicated. We said we had several overdoses over the last several years there, or around there.
Okay, and why did you place that individual in handcuffs?
He attempted to start the vehicle even though the vehicle keys weren't there.
Objection, Your Honor. I would argue that that's a mischaracterization of the evidence.
That was on the video.
It was a mischaracterization of,
His testimony on the ride. He initially testified that the handcuffs were placed on because he was hurt. He was worried that the car was running. Then on cross-examination, he had indicated that the car was off.
Well, I think he's implying that he's just worried about the driver taking off while he's making contact. I think that's the essence of, but then he can correct me if I'm wrong.
your objection is overruled. If you remember the question, you can answer the question.
One more time.
Why did you place the individual in handcuffs?
I removed him from the vehicle because he attempted several times, even after the vehicle was turned off, that he attempted to, he wasn't coherent.
Okay, was he under arrest at that point?
He was just being detained at that point because I wasn't sure what his motives or intentions were.
Okay, and my last question is, why did you ask Officer Adams to search the vehicle?
I was speaking to Mr. Clark in the back seat of the patrol vehicle. And I asked Mr. Clark if we could look inside his vehicle. He said, sure. On watching the video, I said, do you mind if we look in there? And he said, no, sir.
But you also mentioned certain reasons in that video, correct?
Yes.
Nothing further, Judge.
Thank you. Sergeant, thank you for your testimony. You may step down. Your next witness, sir.
Judge, the people call Officer Adams.
Good afternoon. First and last, and then spell them for me, please.
Officer Chad Adams, CHAD-ADAM.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please come have a seat in this black chair that's closest to me. Mary Ann is taking down your testimony, and for some reason, she's unable to hear you. I'll either ask you to keep your voice up or move closer to that microphone.
Yes, sir.
Thank you.
Good afternoon, Officer Adams. Can you please restate your name for the record?
Officer Chad Adams.
Officer Adams, are you currently employed?
I am.
Who's your employer?
City of Belleville Police Department.
And in what capacity?
Patrol officer.
And for how long?
Almost 4 years.
And were you employed in this capacity on December 30th, 2021?
I was.
Did you work the state?
I did.
Did you work the state by yourself or with a partner?
I was in a solo patrol vehicle as well as there was 2 other officers on patrol.
What are,
Your Honor, I'm sorry to interrupt, but I thought there was a mutual sequestration where that was. I don't know if Mr. Officer Adams stayed in on.
He was sitting in here and, I'm sorry, not officer. Mr. Mohammed specifically said other than the OIC and Officer Adam.
and Judge, I will just state for the record, this officer will only be testifying into where he recovered the drug exactly, if the testimony is required for that even.
Do I recall your exceptions?
I think I
Correctly.
do recall requesting an exception for the OIC and stating that Officer Adams is also here in the courtroom. I don't
Thank
know
you.
exactly my, the words I used in regards to who was accepted, but I do recall bringing to the attention of the court that Officer Adams is in the courtroom.
You may proceed.
Thank you, Judge. Officer Adams, were you working this day by yourself or with a partner?
I was solo patrol in my own patrol vehicle as well as there was 2 other officers in their own vehicles.
Okay, and were you in full uniform or modified uniform?
Full uniform.
And were you on foot patrol that day or in the scout vehicle?
Scout vehicle.
Okay. And did your duties on that day take you at or near the location of 300 block of Main Street?
Yes, they did.
Okay, is that located in the city of Belleville, County of Wayne?
It is.
Okay, what took you to that location in the city of Belleville, County of Wayne on December 30th, 2021?
Sergeant Schreckengoss requested my assistance.
Okay, and when you made that location, what did you observe?
I observed Sergeant Schreckengoss out of his vehicle, standing next to a black Impala parked on Main Street, with the lights. The lights of the vehicle were on. He appeared to be trying to make contact with the driver.
Okay, upon making that location and making that observation, what did you do at that location?
I pulled behind his patrol vehicle and walked up and asked what he needed from me.
Okay, and what did you do next?
I believe he asked me to retrieve a
Objection, Your Honor, hearsay.
It is, Judge, I'll rephrase. Please don't say anything another person said that would be hearsay, only what you said and what you did.
Okay, I retrieved a lockout tool, a Slim Jim tool.
Okay, what else did you do? If anything.
I just asked him what he needed, and
okay, after that conversation, what occurred?
Sergeant Schreckengoss attempted to wake the male. We were pointing flashlights in the windshield. He was tapping on the glass.
Okay, what did you do after that, personally? What did you do anything else after observing that?
We opened the door and requested the male step out. He was very confused and lethargic.
Okay, let's just fast forward past that point. What was the essence of your role in regards to this investigation?
After the male was in the back seat of Sergeant Schreckengoss' vehicle, I was asked to search the vehicle. He requested I do that.
Did you search that vehicle?
I did.
And did you recover anything?
I did.
What did you recover?
I recovered a marijuana smoking pipe, a jar of marijuana in the top of the center console, and then directly underneath a separate tray, I located a plastic Tupperware container with a crystalline substance in it, which I believe to be narcotics.
Okay, that crystal substance that you recovered, that was in a container. What did you do with it?
I put it on top of the vehicle and advised Sergeant Schreckengoss of what I believed it was.
And then after you put it on top of the vehicle, what did you do with it?
It was field tested by another officer.
Did you remove it from the top of the vehicle?
I did.
What did you do with it after you removed it?
I believe I brought it back to Sergeant Schreckengoss.
Okay. And that individual that was in that vehicle, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that individual is wearing?
He's behind you and he has a black trench coat on.
Can you please point to that individual? Your Honor, just let the record reflect that this witness has pointed to the defendant. He's also mentioned in his testimony that he's the officer who recovered the drugs and handed it off to the sergeant. Nothing further to this witness.
Your witness, ma'am.
No, I don't see any questions.
Thank you. Officer Adam, you may step down. Thank you for your testimony. Your next witness, sir.
No further witnesses, Judge.
Any witnesses, ma'am? Argument.
Judge, the people moved to bind over on the count of possession of methamphetamine. As you have in your possession is the MSP lab report that shows that the drugs recovered here were indeed positive for methamphetamine. The testimony today by the sergeant was that he was just patrolling the area and he observed an individual which appeared to be potentially slumped over the vehicle. He then, upon making that observation, made a round around the block and approached parked his vehicle behind the individual and approached the vehicle. As you can see from the video that was played today by defense, the officer attempted to make contact with that individual. He shined his light multiple times inside the driver's seat. It appeared to be that he knocked. There were several attempts to try and make contact with that driver. That vehicle was running. It was in a main road. From what it appeared from the video, nobody else was on the road. The officer had reasonable suspicion to approach that vehicle. He did nothing wrong at any point, in my opinion, upon approaching that vehicle. He attempted to make contact. There was failure of a response. He then contacted for other officers to respond. they also tried to make contact with that driver, as you could have seen in that video. Due to those failures, the officer believed, based off testimony, that there was some serious medical crisis or something was going on that was more serious. In my opinion, that is an exigent circumstance. And so the officer at that point decided to get a lock tool and attempt to get into that vehicle. Upon making entry into that vehicle, he observed the defendant. He attempted to make contact with the defendant. The defendant seemed a little hazy, not sure where he was. I think he referred to the officer as baby. I think his head or his elbow kept hitting the steering wheel and hitting the horn. He seemed really out of it. At that time, I believe the officer, in my opinion, believed that this individual was under the influence, whether it's drugs or alcohol. I think that that observation did give him probable cause to search the vehicle for drugs or alcohol. Furthermore, the testimony reflects that he took that individual and placed him into the back of the vehicle. That was a safety concern, is my understanding, based off of the officer's testimony. During that time, he received consent. Now, whether that consent was consensual, even if it's not, I think probable cause still exists. Lastly, Judge, I believe that the testimony reflects that there was only one individual in this vehicle and nobody else could drive this vehicle. And it seemed clear from the video and the testimony that this vehicle was going to be towed. They were not going to have this individual drive this vehicle. And as a result of that, I believe that they would have discovered this drug based off of an inventory search, even if there was no probable cause, which I definitely believe exists here, Judge. So based off of that, I believe the people have met our burden as to probable cause, this low standard, to have this individual bound over to circuit court, Judge. Thank you.
Ma'am.
Thank you, Your Honor. The defense maintains that the prosecution has failed to establish probable cause that would warrant a bind over. Moreover, a court should consider lawfully obtained evidence during a preliminary, even at a preliminary examination, regardless of whether the standard is probable cause or not. The officer in this case, in our opinion, impermissibly extended the stop without having reasonable suspicion to further detain Mr. Clark after the officer's initial contact with Mr. Clark dispelled any concern about an overdose or any sort of medical crisis. Moreover, Mr. Clark was ordered out of the vehicle. He immediately was handcuffed. He was searched and then escorted back into the patrol vehicle. The officer in charge testified that he was handcuffed this entire time. When he was placed in the back of the patrol vehicle, he was not free to leave. The back of the patrol car automatically locked. He couldn't go anywhere. There was also two other officers on scene. As evidenced by the video, there was also the overhead activated lights that you could see with respect to that, Your Honor. The officer asked him specific questions while he was in the back of the car, potentially interrogatory questions, and then asked Mr. Clark, or potentially threatened a criminal charge about an OWI, and then asked him to search the car. He had to ask Mr. Clark that question twice before Mr. Clark reluctantly said, no, sir. It's our position that the consent to the search in this case was not a voluntary consent issue, and that any evidence obtained following the consent to that search should be excluded as fruit of the poisonous tree under the Fourth Amendment. And we would ask the court to dismiss this case at this stage. Thank you.
Thank you. This court denies the request to dismiss the case and will find that the people met their burden for purposes of preliminary examination. Sergeant was clear in his testimony that he was driving on Main Street, noticed what he believed to be an individual slumped over in the seat, rounded the block, came up, could not rouse the individual. And although defense counsel made arguments regarding no convulsions and no foaming at the mouth, something was afoot. And Sergeant took reasonable steps to figure out what was afoot sufficient to secure public safety. His testimony was that the vehicle was going to be towed. There was a search incident to removing Mr. Clark from the car and preparing the vehicle to be towed or otherwise secured. Officer Adam testified that he located the envelope and then, or the packaging and then the Tupperware package. And there was a discovery of the information of the materials which have been more specifically identified in the MSP report to be container number 1 and container number 2, finding therein 0.8652 grams of meth. The people haven't met their probable cause standard. Mr. Clark will be bound over as charged to have an arraignment on the information that will occur on March the 6th, 2024 at 9 a.m. His previously entered bond with any conditions will continue. Was there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else on behalf of Mr. Clark?
Nothing further, Your Honor.
Thank you. That concludes this matter. Did you need your report back? Mr. Mohammed,
I'm sorry, Judge?
did you need your report back?
Oh, yes.
Thank you. And you had a 1 o'clock with Mr. Schlaff, and I saw Mr. Nunley out in the hallway.
Yes, Judge. I'm gonna go speak to witnesses now. Thank you.
We'll take a brief recess. Thank you. Good to see you. Officer Wickham?
This one. Oh, that's not. Because everybody's here. Okay. The only thing is on that, well, it doesn't matter with Carrie, because the prisoner's not here.